What if ultimately, you make an assessment and you get it wrong, and you think you're essential, you're continuing the work, but ultimately you get an inspector on site and they say, nope, you're not. The fines are quite heavy, and that's part of the reason why there's a recommendation for these indemnifications. If it's deemed that an owner, a contractor, subcontractors fail to comply with the owner, an individual can be fined up to $100,000 and face up to a year imprisonment. Corporations can be fined up to $10 million, and corporate officers and directors each can be fined up to $500,000 and also be imprisoned up to a year. I caution you, however, I have spoke with a few of the inspectors from the ministry. The bottom line is, as they've said, they're not out to get you. If they attend at a site and they see that something doesn't jive, something doesn't comply, or whatever the case is, they're likely to give a warning first before, strictly imposing a fine. And again, these fines are sort of the maximum amounts. And you're looking at having a fine to this extent imposed if there's a flagrant disregard of the warnings that have been provided, or if it's quite obvious that the work that you're doing has no essential purpose as set out in the list. So I caution you in relation to that. Even if work clearly fits into any of the sections of the essential services list, that essentially just means that the work can continue. Really, whether or not it should or it must continue, that's a contractual issue. So you really need to look at your contract documents to see, if there's any paragraphs in there that deal with, events that may prevent a party from performing, or events that interfere with a party performing any obligation under the contract. Where that event is obviously beyond that party's control and it's not their fault. Look to see as well if there's anything that speaks to who may bear a financial burden of a stop work order, or of the continuation of work on a project. Specifically, look to see in your contract if you have something that's referred to as a force majeure clause. And within that, look at the language to see, if there is reference to specific, disease, pandemic, epidemic, quarantine, or, if there's a broad reference to a government or administrative action. Look to see as well if there's any paragraphs that relate to delay. Even if the project is stopped, a concern for a lot of parties on the project, an owner, contractor, whomever, is, okay, now what? We're being delayed. Who's going to bear the costs of this, and the damages that flow? Who will bear the burden of those? So, for example, if you look at a standard CCDC2 contract, the stipulated price contract, there's a section 6.5 that deals with delays. And that paragraph, as an example, and of course, it could be varied by supplementary terms, but it sets out that if the contractor is delayed in performing their work because of a stop work order by the court, or in this case, another public authority, the contract time can be reasonably extended, and the contractor will be reimbursed by the owner for reasonable costs incurred because of the delay. With any of these paragraphs, first step is looking to see whether such a paragraph exists. And then also next, you want to see if there's any notice requirements in relation to those paragraphs. For example, if there is delay, or if there is a force majeure event, there's a timeline that should be set out as to when you need to give notice and how you need to give notice, if it's in writing and so on, et cetera, of that event. And if you don't, you may, within that timeline, you may void the rights under that particular paragraph. The other thing you want to do is constantly take note of the impact of, the impact on performance as a result of a stop work order, delay, and so on, et cetera. So that you can take note of sort of what's happening on the project and when, delay, and so on, et cetera. Now, if you ultimately go back on to the project, a couple of things. If you go back on because the project has, let's say the project has been closed and you have to go back on, you have temporary access. You'll only be able to go back onto a closed site to complete inspections, maintenance, and repairs, to allow for security services, to deal with any other critical matters relating to the close of the place of business. Of course, if it can't be dealt with remotely, and to access materials, goods, supplies that can be necessary for the business to be operated remotely. That's in the event that the project is closed. If, however, you are deemed to be able to attend back on site because it is an essential service, then there's other precautions that you need to take and be leery of. Firstly, be prepared for increased inspections by the Ministry of Labor. There's more of them out there, and in light of this list, they're attending more sites to make sure everyone's in compliance. If anybody, any workers or otherwise have any, cold, flu, or COVID symptoms, they need to be sent. Home. Everybody on a project, whether you're an owner, a constructor, an employer, supervisor, or worker, you all need to comply with the regulations and the obligations and duties set out under the Occupational Health and Safety Act. Those are available on again, Ontario.ca website, and any other directives that are coming in from the Chief Medical Officer of Health. So very quickly, obligations include the following. There's a responsibility to maintain a sanitary job site. The constructor is required to provide facilities. These include a sufficient number of toilets. For example, 1 toilet for every 10 to 15 workers. They need to provide hand washing facilities on the job site. And each one of these things, the toilets, the washing facilities, and so on, et cetera, they all have to meet standards that are set out under the Occupational Health and Safety Act, and they need to be regularly serviced. That includes pumping, cleaning, being sanitized. Hand sanitizer, soap need to be made available. Drinking water needs to be available on these sites. There's also a recommendation that at least 2 meters of physical distancing be implemented. So, you want to minimize the groups of workers. You want to stagger the start and end times for breaks, lunches, and so on, et cetera. You want to restrict the number of people that are ultimately on site. Restrict the amount of personnel on hoists and elevators. Any meetings that are held, morning meetings, for example, they're to be held in outside in larger spaces to enable physical distancing. If multiple trades are using the same tools, then that should also, they should be regularly sanitized. Again, hand washing practices, wearing gloves, coughing into your sleeve, all of those things need to be enforced. And just to conclude it, the employer and constructor need to post and communicate these policies to the employees and to the trades on site. And those are all available, as I said, all of that list is available on the Ontario Chief Prevention Officer regarding construction, health, and safety during COVID. That's what the document is referred to. It's on the Ontario.ca website.
Thank you, Iris. I think there's a lot of information in there for
yes.
Various clients in dealing with these issues. And obviously, if anyone has any further questions or any questions arising out of the material or otherwise, please feel free to reach out to Iris directly. She'll be glad to help you out. And now
Absolutely.
We're moving on to our next panelist, Jonathan Borelli, in the area of labor and employment. He heads up our department there and is going to provide us with a little bit of insight on some of the issues that people have been dealing with, struggling with as a result of the unique situation we're in. So Jonathan, why don't you take it away?
Sure. Thank you, Ian. Hope everyone can hear me. Allow me to just share my screen here. So thank you very much for joining us, everyone. My name is Jonathan Borelli, and I'm part of the Labor and Employment Department at KMB. And my colleague Rosalie will be joining us as well for the second part of the employment law section. And really these the things that we're going to be talking about is more of a higher level overview. And if you require any detail about what we're talking about today, I'm happy to give more detail after today's webinar. And so we're calling it the new normal because there will be, of course, some changes within the workplace that I think every workplace will have to deal with. And so I'd like to give everyone some practical considerations as well as an overview of what the law says that employers have to undertake. So just briefly, what we'll be talking about for the employment portion of today's webinar is managing health and safety, which is of course top of mind. I'll briefly go over work refusals. I'd like to talk about the wage subsidy program that's offered by the federal government. And Rosalie will be talking about specifically dealing with COVID in the workplace and also managing layoffs and eventually recalling those employees. And of course, we're happy to take any questions that you have during the webinar or through Ian, our moderator, or afterwards. So we'll start with health and safety because, like I said, this is top of mind for governments, for employers, for everyone. And the most important obligation, and there are many obligations that employers have for health and safety. I would say the most important one is that employers provide they take all reasonable precautions to protect the workers in the workplace. Okay, so the wording there is key, of course. What is reasonable for one workplace might not be reasonable for another workplace. So what is reasonable depends on the particularities of your operation and your workplace. And it's to protect all workers, okay? A worker is not necessarily just limited to the employees in your operation. It is limited to any person that works or interacts with the operation. And so I'll be using the word workers, but this also includes contractors who maybe are doing work in your operation, or people who do deliveries. They would be covered under bringing deliveries to the operation, covered under the type of workers that employers have to protect. So employers have a general obligation to provide or to take all reasonable precautions. So what are some of those reasonable precautions that I know employers are taking right now? Well, first of all, I think working from home is important. And if it is possible for productive employees to work from home, even when the province starts reopening society, then it may be reasonable for the employer to do so. If at the point where employers can get their workers back into the workplace, training is going to be very, very important. Every worker needs to understand the PPE that the employer is using, the measures that the employer is taking to protect all of the workers, and that can be done virtually or through a policy manual that the employer has. So training is key. Physical distancing, in my opinion, is not going to go away. So physical distancing, meaning at least 2 meters apart between workers at all time, that is going to continue. So that may include barriers within the workplace. That may require, a retooling or a reconfiguring of certain areas of the workplace. I mean, top of mind for me is a lunchroom. And I know what we've done at our office is to spread out the chairs and in fact remove some chairs from the lunchroom to ensure that any people who are sitting in the lunchroom are sitting at least 2 meters apart. It may also include changing how meetings take place in the office. We've seen one-way traffic in grocery stores. Those are all different things that an employer could do to ensure physical distancing. PPE refers to personal protective equipment, and that would be, of course, the masks and gloves and face shields, and of course, whatever is reasonable. For some employers, they may already utilize those PPE, but for certain workplaces that don't already use that, we're going to see more of that PPE and personal protection equipment being used. Hygiene, of course, is very important. I think it's important for everyone to know how to wash their hands properly according to public health guidelines, and also having hand sanitizer available for workers to use. Active screening is a term that is being more used in employment law. By active screening, what I mean is the employer taking steps to monitor its workforce. And so, first of all, that would necessarily include a policy. You have to have a policy regarding how the employer is going to monitor employees. Screening workers before they're entering into the workplace is key, and that may include temperature screening as well. But it could also include maybe a general questionnaire before employees enter the workplace. Do you have any symptoms? Have you traveled outside of the country in the last 14 days? To understand the workers that are entering the workplace on that day. And the more that close contact and contact tracing becomes more common, that information is going to be key. And also, I would say, as part of active screening, is rapid isolation. Having a policy, if there is someone with symptoms, that there's a policy to rapidly isolate that person. Temperature screening, I could do a whole presentation just on temperature screening. So what I'll say is this: I believe it will become more common, and in fact it already is for airlines in the province, in the country. Temperature screening will likely become more common, and it is important that employers do it reasonably and prudently and carefully. So usually those types of tests are not permitted just on a random basis. But I think we're in a new, like the title of our section today, we're in a new normal. And so temperature screening will likely become more common in the workplace. And there are some obligations for employers to report certain infectious diseases to certain government offices, and that should be a part of an employer's reasonable precautions for health and safety. I'd like to talk briefly about work refusals, because I've already helped some employers with employees who refuse to come back to work because they believe their work is unsafe. So there are several steps that an employer can take to manage work refusals. At a minimum, the employer should undertake an internal investigation to understand, essentially to understand what the employee is getting at, and why that employee feels they believe their work is unsafe. And so an internal investigation, there's no set format. I think it's just important to understand where the employee is coming from, take notes when you talk to that employee, have the employee formalize their work refusal. If the situation is not resolved for the employee at that time, it may be necessary to call the Ministry of Labor to complete their investigation as to whether the work that the employee says is unsafe is indeed safe or not. And the consequences of a work refusal, there are at least two different things that an employer can do to manage a work refusal. So number one, there is an ability for the employer to provide the employee with an unpaid leave of absence, okay? And my colleague Rosalie will be discussing that just in a few minutes. And there are certain job protected leaves of absence that an employee can take, the employer can give to the employee, and that can deal with the employee's issues regarding unsafe work. If the employee does not have a genuine reason and the work has been deemed safe by the employer and by the Ministry of Labor, if they still refuse to come into work in a reasonable amount of time, it can be considered a job abandonment. And that means that their employment could be terminated for a cause. And of course, we would do this very carefully. Of course, as I mentioned, after doing investigations for into that unsafe work. But those are at least two options that an employer has in dealing with refusals to complete unsafe work. The last part I'd like to go over is the government support regarding, of course, assisting employers to get back and reopen their businesses. So there is, of course, the wage subsidy program that the government is offering for employers. And to be brief, this is a subsidy of 75%, up to 75% of an employee's wages for certain periods of time that the government has set out, as long as the employer can show, or the business can show, a drop in revenue of 15% for the month of March, or 30% for the month of April and the month of May. And so the applications are now open, and I know of many employers who are already taking advantage of the program for the month of March. And now that the month of April is done, employers are taking a look at their revenue numbers to understand whether they can obtain that government support for the employees that they paid in the months of March, April, and May. There are other ways that the government is supporting employers, either through new legislation or existing legislation. A staggered return to work is something that I know some employers are doing. And what I mean by staggered return to work is when you have employees who, let's say an employer has laid off all of their employees. There is a way using the current rules of layoff to bring some employees back for certain periods of time and keep other employees on layoff. And so you stagger their return to work. Because a layoff, and Rosalie will be discussing what exactly, the nitty-gritty of layoffs. A layoff does not necessarily have to be consecutive weeks in a row. An employee can work, they could be laid off for 8 weeks, they could come work for 2 weeks, they could be laid off for an additional 2 weeks, and it would still be considered a temporary layoff. And there are some cases, as long as the employer satisfies certain requirements, as in continuing the employee's benefits, the employee could be, this staggered return to work could take place for up to 12 months, up to 52 weeks since the beginning of the layoff started. So those rules already exist in terms of temporary layoffs and bringing certain employees back to work in order to support the business. So that is, a tool that's available in the employer's tool belt to manage their expenses and to slowly ramp up. Of course, I'm sure everyone has heard about CERB, the Canadian Emergency Relief Benefit. There are ways for employees to go back to work and still receive their, emergency benefits from the government. So that's something that could be discussed or negotiated with an employer and employee. Will get them back to work. And again, this is probably with the staggered return to work, like I just mentioned, that you can have the employee return to work, support the business, and ramp up the business. There are 2 other government programs that currently exist. One of them is the work sharing program and a program to supplement EI benefits for employees. And essentially, these are agreements between the employer, employee, and Service Canada to manage an employee while they are in receipt of government benefits and still working. So the programs are a little more detailed than what I'm providing here, but those are options available not just for the immediate period, but once the emergency is declared over and once the economy gets up and running again, and those employees may not be in receipt of CERB, but they may be in receipt of employment insurance, regular employment insurance benefits. There are ways for the employer to either top up their pay using supplemental EI payments, or to arrange their workplace with at least 2 workers through the work sharing program to allow the employee to earn some income and still be in receipt of employment insurance benefits. So it is possible to manage employees, once the province allows the workplaces in Ontario to reopen, to manage costs and to keep the business running smoothly. So those are the various areas of government support. And I'll save a little bit of time now to address any questions at the end of the employment law presentation. So what I will do is I will send it over to my colleague Rosalie, who will be discussing dealing with COVID in the workplace and also layoffs and recalls.
Hello, my name is Rosalie Springer, and I'm a labor and employment lawyer with Jonathan Borelli. And I'm just going to share my screen. Okay. Did we get it going? 1 second. There we go. Okay, lovely. So I will be talking today about best practices for employee management and COVID-19 in the workplace. So as Jonathan mentioned earlier, first and foremost, there really are obligations for the employer under the Occupational Health and Safety Act to take all reasonable precautions to keep your employees safe and healthy. And so that can be as easy as creating a workplace policy for COVID-19 or infectious diseases. And the policy should be something that's flexible, should take into account that there are potential future changes with the legislation that may happen. And it might involve coordinating with your joint health and safety committee or any kind of safety representative that you have in your workplace before it's finalized. So it's a collaborative effort that works together with the employees as well, who are so important in this process. And the policy should include what to do when an employee, for example, has symptoms, what to do when an employee has traveled outside of Canada or has come into close contact with someone who has a confirmed case of COVID-19, and any kind of sanitization procedures that are in the workplace, as well as physical distancing or just the general procedures that are happening right now for safe and healthy work going on during the pandemic. So essentially all the information and tips I'll be providing to you today will be and should be folded into your workplace infectious disease COVID-19 policy. So this will allow you, of course, to have all the concrete answers at your fingertips as best as you can in the moment. And you'll be able to provide this to your employees so they can know what to do when the time comes when they, for example, have symptoms or have questions about sanitization procedures. It's all sort of there and laid out for them. So for example, if you have an employee with symptoms, as I mentioned, this should be folded into your policy so that they have access to the answers for this. But someone in your workplace, an employee, informs you that they've been experiencing symptoms and they've come into the workplace. What do you do? So first, you would investigate the situation. So you'd ask them questions. You could ask for details about when they started experiencing the symptoms. And this, unfortunately, may involve you having to send other workers home who have been in close contact with that employee for 2 days prior to when they started experiencing the symptoms. And I'll explain what this close contact definition really means shortly as well. But that is unfortunately the case. But again, you have to ensure that employees are the first and foremost, the priority in the workplace. They're kept healthy and they're kept safe, and that's extremely important. So you can then send the employee with symptoms home to self-isolate for 14 days and limit contact with others. And this, again, involves, of course, not coming to the workplace at that time. In terms of them getting home practically, we think that it's reasonable to perhaps if you choose to, pay for their transportation home if they don't drive to work. This may involve, giving them some funds towards taking public transit, and of course reminding them the importance of wearing all personal protective equipment and abiding by for example, the TTC rules, so standing 6 feet apart from other people on the public transit. You also, in terms of paying them, if they're an hourly worker, we recommend paying them for the 3 hours in accordance with the 3-hour rule of the Employment Standards Act. And then if they are not hourly workers, you may pay them for the day if you choose to. But again, this is something that you would determine yourself based on your policy. So you'd again request that they consult the self-assessment tool. This is extremely important because they'll need to see what steps they have to take in order to come back to work eventually. So you could also recommend that they call a doctor, public health, telehealth about their specific condition and see when it's safe for them to come back to work, because it might be after the 14-day period. It's really dependent on the circumstances and you can't really make that call. So it's also important that you inform them that they will not be terminated as a result of disclosing that they have symptoms. This is extremely important because, you can't terminate someone for an illness. It's unacceptable. So, and also inform them that you'll keep all their information confidential, and that's very important as well. During this time, if the employee's work permits, or if their position permits and they're able, they can work from home, and they can do so also during the 14 days and until they're told to return, either by, again, public health or by their doctor. If the employee is not well enough, they can take the unpaid job protected leave of absence, which again, I'll get to as well. And you want to make sure the employee ensures that they regularly update human resources about their health condition and what's going on with them, and when they perhaps can come back to work. So the next question would be, you have an employee who has been in close contact with somebody who has been diagnosed and has a confirmed case of COVID-19. So again, you ensure that they report this to the human resources at your workplace. And this would be in two cases. Either they're told directly by the person who has a confirmed case that they have that confirmed case and they must inform and they were in close contact, or public health calls them. We're hearing this now more frequently, that public health is calling those who have confirmed cases, so they'll have to inform as well. And employees might be, a little bit nervous about doing this, but it is important you stress to your employees that it's necessary to ensure the health and safety of the workplace and all other employees, so that they do make sure they inform human resources. So again, the same thing as what I said earlier, the employee cannot be terminated for disclosing this information, and you should tell the employee to return home immediately and self-quarantine for 14 days and follow the same protocol, again, as I said, if someone has symptoms. So now turning to what the definition is of close contact. So according to the self-assessment tool, we understand that close contact could be a myriad of things. It could be having a face-to-face conversation for 15 minutes. It could be being in the same room as somebody for 2 hours. It could be living with or otherwise having contact within 2 meters with a person who had a confirmed case while they were infectious. It could also be that someone provided care for the individual, family members, healthcare workers, or other caregivers without proper personal protective equipment. So again, masks, gloves, all those things. And it's also direct contact with someone who has infectious bodily fluids. So if you've been sneezed on or coughed on, anything of that matter. So now if we get to what would you do if an employee has traveled outside of Canada. So this would be, of course, there are now federal rules and requirements around this. So the government has put in place that anyone who returns to Canada has to isolate for 14 days if they have symptoms, or they have to quarantine if they are asymptomatic, which requires, again, them to limit contact with individuals and not to go into the workplace at that time. So this would, again, be folded into your policy to ensure that you, as the workplace and the employees, are complying with the federal guidelines. So again, this would also require that they would inform the management or human resources when the dates that they traveled, provide them with the dates that they traveled, and again, follow the same protocols as with when someone has symptoms. So they'd have to, again, contact telehealth or their doctor and see the recommendations, because even if they don't necessarily have symptoms, people could be asymptomatic and still be carrying. So now we'll go on to this Employment Standards Act leave of absence, which is a new leave that has been put into place. So employees now are entitled to this new statutory leave of absence, which is called the Declared Emergency or Infectious Disease Emergency Leave. So what this is an unpaid job protected leave, meaning that you as the employer have to reinstate the employee to the position that they most recently had, or if it's no longer available, which we understand that in a lot of cases, given COVID-19, some positions are being eliminated, they have to be placed into a comparable position. So this is very important. So it's also important to note that in terms of this leave, you cannot threaten as the employer, terminate or penalize an employee for taking or planning on taking the leave itself. You should provide benefits to continue during the leave, and the leave ends in accordance with the Employment Standards Act. It says that once the specific reason for taking the leave ends, or when the declared emergency or infectious disease is over. So those are sort of what happens when the leave ends. So there are various reasons when an employee can take a leave. So we suggest you consult the Employment Standards Act for the full list and all of the very specific wording that includes it. But essentially, employees can take the leave if they're sick, in quarantine, or in isolation. If they are in quarantine, isolation, or subject to a control measure as a result of information issued by public health, by a public health official, a nurse or a doctor, or telehealth, or the government of Ontario or Canada, or a board of health. Or if they're directly affected by travel restrictions and cannot get back. So again, you can only request the employee come back in a reasonable way. So having them take 3 buses and a plane, not necessarily reasonable. The most important power that this new Employment Standards Act leave of absence provides is that actually employers are now permitted to place an employee on this leave and require them to self-isolate and quarantine if they are concerned that the person may expose other employees to COVID-19. So we want to caution you though on this because, of course, give us a call. We'd be happy to discuss this with you and all the specificities behind it. But it can't be something trivial. So if someone coughs once or sneezes once, that does not amount to COVID-19. We're not doctors. Most people who are listening to this podcast are not doctors. They can't make the firm assessment whether someone, has a confirmed case. So it's a slippery slope. So you definitely don't want to be too, overzealous with putting employees on leave. And right now, it's not very clear how far this power stretches. So in terms of the notice requirements, the employees have to give notice before they go on leave, but if they can't, then they can give notice. We recommend within a week of the start of their leave. So that can be done verbally or in writing. And we believe that a best practice that should be in place and folded into your policy would also be that you request your employees to give notice before they return to work. And this again can be verbally and in writing and will be included in your policy so they'll know what they're supposed to be doing. So in terms of what qualifies for the leave, there are certain, things that they can submit to you to say, I believe that I should be on this leave and here are my reasons why. So right now, you cannot request an employee to prove that they should be going on the leave. You can't request them to provide a doctor's note. And this is something that's very clear and unacceptable to do. But you can, for example, ask them to provide travel documentation showing they traveled outside of Canada. And again, the evidence that they provide to you has to be reasonable and provided within a reasonable time frame. So if, for example, the employee is in quarantine, you cannot request them to leave their home to get this evidence. This also can include a copy of the information issued to the public by a public health official. And this can be actually in the form of a screenshot, a printout, or a recording. And this is what the Ministry of Labour has said, which is very interesting. Now I'd like to move on to temporary layoffs and recalls. So a temporary layoff is a temporary stoppage of work due to a downturn in business. This is what a layoff is, a temporary layoff. That is not the same as a termination, and it's very important you know this. In terms of who can you lay off, you can lay off as many people or employees as necessary for the business needs. So the employee, though, has to be recalled within a certain period of time. Otherwise, the employment is actually terminated as of the first day of their layoff. So that's important to note. So there are 2 different kinds of layoffs. There's a short layoff and a long layoff. So the short layoff is 13 weeks in a 20-week period. And then a longer layoff is more than 35 weeks in a 52-week period. But this can only continue if you provide benefits to them throughout this period. So we recommend that during the layoff, you start the benefits from the day 1 of their layoff and continue till the end, because that's the best practice, just in case you want to extend the layoff further. So when the person is laid off, you have to provide them with a record of employment. We recommend you stay in touch with the employees over their leave. Make sure you have their most up-to-date contact information. It's important also for the temporary layoff that you understand that there is no automatic right to lay off employees. So although the Employment Standards Act does provide a right, you need the employee's agreement either in their employment contract prior to the layoff or at the time that you're laying them off in order for them not to potentially start a constructive dismissal claim. However, given the unprecedented situation, we believe that you could still force a temporary layoff, and that it's unlikely that the courts will hold that you're liable for months and months of pay during this specific time. So I'd like to quickly speed through my last few points. In terms of recalling employees back to work, you can recall whichever employees you choose based on what the business needs are. But as a best practice, you should document a short-term and long-term plan for recall. So, maybe you recall the best performers first, the full-time workers first, and again, they have to be returned to the same or a similar position if their position no longer exists. So the employee on recall has to return to work within a reasonable time after being recalled. So you don't have to be recalling them constantly. They should be recalled and then return, and they would continue working in good faith in their position and meeting the required performance standards that they had prior to the leave. So there are a few special considerations I do want to note for the employer when they're recalling. So again, you want to keep in mind human rights issues. You don't want to make it appear as if you are selecting certain employees with only certain characteristics. So for example, you recall back only people who don't have children. This is something that might be a human rights concern. And we believe that this is sort of something that could appear to be problematic. Recalling only single people, that's something that could be an issue as well. Women versus men. So you want to note all the potential human rights issues. And again, even if you know that someone might not be able to return to work, for example, people who have children, you may request that they return part-time, and you may offer this to them so that they are aware and understand that this is still, an option for them, and it's important that they're included in the workplace as well. And they might be able to arrange alternative childcare for their children. So you definitely want to lastly provide as much notice as possible when you're recalling the workers so that they can get all their affairs in order. Lastly, I'd like to point to some resources that we have here. You can feel free to email us or call us, and we can provide you with the slideshow that gives you sort of a lot of really great tools that we've compiled, and you can look at those through our links. So now we have Jonathan back, and we'd love to open the floor for any questions that you would like to ask. Thank you.
Right, and we've already received.
Shocked to hear that we have had an enormous amount of questions for employment issues around this. And I'm sure that you'll be able to pick through, but one that came up that I'll start with out of the group as we sort of pick is someone asked the question, what if you need PPE as an employer, but based on what's going on, you have great difficulty or you can't get a hold of sufficient amounts of PPE in order to reopen? What's the answer if you're an employer?
Yeah, I mean, the short answer is if the employer doesn't have that PPE, they may not be able to open right away, or they may not be able to reopen as fully as they would like. Okay, and that might not be the answer that every operation wants to hear, but the law is clear that the employer must provide, they have to take all reasonable precautions. And I think, in my opinion, providing an employee with a mask, it might not be reasonable for them to bring in their own mask. That would be, of course, helpful. But if the employer can't provide masks and gloves and perhaps a face shield or perhaps barriers like we're seeing in grocery stores, it may, slightly delay when the employer can fully ramp up their operation. And so if it's reasonable to have only 2 employees, let's as a hypothetical, instead of having 10 employees that are in an operation, if it's limited to 2 or 3 employees who can stay more than 2 meters apart, then it may be reasonable to reopen. But if there are many employees in close proximity to each other and they don't have access to reasonable PPE, it's the employer's obligation to provide that.
So what I'm hearing really is, since it's a precondition that has to be satisfied by the employer, it's the employer's responsibility, no matter what.
Mm-hmm.
It is, yes, and I know it's difficult.
Now, I think there was another point in here I thought was interesting. Employers have an obligation to have to provide a safe workplace. They have an obligation that if they think someone is showing symptoms, they have to take steps. Is there anything with regards to an employee, having an obligation to advise the employer that they have symptoms, or advise them that they may be that the employee may have been in a compromised situation?
So as of right now, that obligation on employees does not exist with regards to symptoms. If an employee is tested positive for COVID, then public health will be doing all their contact tracing and following up. But if an employee simply has symptoms, there's no obligation in the law to force them to state that they have symptoms. But like Rosalie said, the law is very clear that they're not going to be terminated, or there's not going to be any discipline against an employee if they do report that they have symptoms. Now, we're kind of in this gray area period right now where, you know, employers have the obligation to have a safe workplace. So I think the happy medium at this point that employers can take is to have a well-worded policy that, you know, we can't force employees to disclose their personal medical information, but you know, that strongly encourages employees to at least say if they are sick or ill, they should stay home. If they can do their work when they're at home.
Are there circumstances where you can force an employee or require an employee to take the test before returning to work?
So as of right now, you know, this is probably the grayest area in employment law and accommodation. So as it stands right now, you know, it's not clear. And I think as we go through the reopening of workplaces, I think it will become reasonable to, when rapid tests are available and those rapid tests are effective and you know, available, because right now we don't have any rapid tests. I think at the point that we have genuine and reliable rapid tests, I think that would be part of a reasonable employee screening before they get to work. But right now, the only tests we have are quite invasive with, you know, it's either blood or through the nose that the testing is done. And we know that the province isn't really getting through as many tests as they would like to. So there is a balance that the employer has to do between, you know, balancing employee privacy and, you know, using whatever means that are reasonable and frankly, the least intrusive means to obtain that information. So right now,
if you have an employee that shows symptoms and you send them home, you send them home for the 14 days, but you can't require them to have a negative test before they come back. Currently,
what would you say to that, Rosalie?
I would say that based on what we recommend, they should be, you know, free and clear of symptoms, and in order to maintain the workplace and in order to maintain the health and safety of other employees. So yes, if you fold it into your policy, which we recommend, we believe that yes, someone should be, you know, healthy as best as we can sort of say that, given the circumstances, as in free from the COVID-19 symptoms or recovered from COVID-19, and disclose that upon their return to work. So I think it is reasonable to request that they have some kind of free and clear status, and they can get that through their doctor or through who they've been corresponding with about their diagnosis or their confirmed case or symptoms.
now, if you have employees that you've sent home to work remotely, and they need certain tools in order to fulfill their job, whether it's a laptop or even if it's just Wi-Fi, or they have to use their phone, are you required to pay, as an employer, to pay the related expenses because you've sent them home to perform their job function remotely?
Yeah, Ian, you and I could do a whole seminar just on that one topic. So the short answer is, you know, if an employee is working from home and they require certain resources in order to do their job, working for the employer, there may be a lot of cases where the employer does have to, you know, provide those resources to the employee working from home. You know, the working from home situation, it was pretty common in employment law, but of course now it's widespread. And so we're getting a lot more questions about, well, to what extent does the employer have to accommodate these employees working from home? So the short answer is the employer has to do what is reasonable, but of course that opens a whole other Pandora's box. And so what I would say is, you know, speak to us, give us a call or an email, and we can go over the details of that.
Now, we still have a lot of questions left. For all of the people that are watching, it is time for us to switch to our next presenter. But Jonathan and Rosalie, can I ask you to take a look at those questions and reach out to those people directly? And for those of you that send in questions, If you want to jump the gun and email or call Rosalie or Jonathan, we'd be glad to deal with those questions. It's just we've run out of time,
Yes.
and we know there are lots of questions around employment, so our panelists will be glad to help you outside of this webinar.
Yep.
Thank you.
And
both.
I've taken note of all of the questions, and I'll respond to them offline. So thank you very much for having us here, and I'm looking forward to seeing the rest of it.
Thank you.
Thank you. And now we bring in Kevin Fernandez. Kevin and I work together in the corporate commercial department, do a lot of work in the mergers and acquisition side, as well as business relationships and business establishment. So Kevin, you're going to talk to us a little bit about the M&A impact that has come out of COVID-19. So I'll turn it over to you.
Well, thanks, Ian. And yep, so Ian and I work together closely. We're both corporate commercial lawyers, and we practice in the M&A and private equity space. And we want to provide a little bit of insight into what we're seeing from our clients. Our clients overwhelmingly are small and medium-sized business owners, owner-managed businesses, and a lot of them have questions about transitioning their business to the next generation, or questions about bringing in a strategic partner, or buying or selling a new business. So we're happy to provide some insight into what we're seeing so far during COVID-19. So no presentation is great without a disclaimer. So I'll give you the required 5 seconds to read this disclaimer very quickly, and that's it. We'll move along. So I've kind of broken the presentation into 3 chunks, and the way we want to kind of present is kind of highlight what the marketplace looks like now and some of the challenges we're seeing with conducting deals during the pandemic, but then also to spend a significant amount of time in this presentation about where to go after COVID-19 and how to use COVID-19 as a time to pause, reflect, and potentially grow your business or transition to the next phase of your business. So with that in mind, let's get going with the M&A marketplace. So the first point just highlights a trend that Ian and I are seeing with respect to deal activity. A lot of our clients are involved with private equity transactions. A lot of times it's private equity stakeholders looking to finance into a business. And we're noticing that there's a large delay. It's a cooling down period because a lot of PE players are focusing their cash on their already acquired portfolio businesses, not necessarily because they need the money now, but because, as with any business, people are looking at what are my needs going to be in the coming months? How is this pandemic going to play out? And how might this cash need to be deployed in order to keep our portfolio active? So we're not noticing a lot of deal activity in that sense, but we kind of have a lot of deals on the hot stove just with the simmer phase on instead of things being at a rapid boil. A lot of owner management.
Obviously in the marketplace, Kevin, with what's happened, there's been a huge amount of uncertainty, a huge amount of risk. And what we've seen is because of the huge amount of risk, people are conserving cash. That's what they're doing. People who own businesses are conserving cash. People who typically buy businesses are conserving cash as well. And so that's where I think you're coming with the concept of delay. It's not that people have stopped. It's in effect as if people have kind of frozen. And they're waiting just to see when will this be over. How bad will it be as far as its consequences before deciding whether they proceed or not. I think we've seen that. Yeah, we've seen a lot of that.
Exactly. And a lot of owner-managed businesses are focusing their own attention and their own cash internally. Some of our clients are actually noticing an uptake. We're thinking of people in the consumer packaged goods or essential services areas. They're actually seeing increased activity and delay in terms of their desire to sell or to acquire the business. They've got to focus their energy on their current staffing challenges or even management uptake in terms of having to step into the production line or the actual delivery of services during this time.
We certainly have seen if there's anyone who is in the essential, like the small core essential service business, especially PPE or other essential services that people need, based on their actions around us, as we see as sort of observers on the legal front, They are clearly anticipating that the increase in the demand for their products or services is going to continue for a significant period of time because they are acting that way. And you say, what does that mean? I'll give you a perfect example. If you're producing PPE, right now you are still buying more equipment. You're buying more equipment to produce more PPE, which to me says you're not thinking that this is a glut that will be over in a month or two. You're thinking this is a much longer term issue, that you'll be able to justify the money you spent on the expanded premises and the expanded equipment because it's going to generate revenue for a significant period of time. We are seeing a lot of activities like that, which would lead us to believe that even as things calm down and the economy opens up, that a number of these providers are seeing and are anticipating that the change in behavior will be longer term.
Certainly a thematic change, and that kind of leads really well into our next point about purchase price justification. The biggest thing we see when we're negotiating transactions is what's the price going to be and how are we going to pay it? Well, if we're trying to justify a certain purchase price based upon repeatability of earnings and a certain valuation, COVID-19 has thrown a huge monkey wrench into the whole equation with respect to showing repeatability. If we are seeing a shift in business or a shift in the direction of the business, how will that change the overall nature of the business, the repeatability of cash flows, and the underlying valuation? It's going to take a little while to ride out and give potential purchasers or potential person that you're acquiring, a company you're acquiring, give everyone comfort about what they're getting when they purchase or sell the business. So let's move along to transaction dynamics. So Ian and I put out an article in the past month talking about, hey, what are deals kind of looking at like, and what do we see? And we kind of focus on material adverse change clauses. And Sean Singh, who's our colleague from our litigation group, is going to talk about a similar concept, force majeures, and talking about these cataclysmic events that can happen that can kind of change the nature of a contractual relationship or a negotiated relationship. But what Ian and I put in our article was a focus on what purchase agreement mechanisms are there that can help purchasers and sellers deal with allocating risk. And we've kind of divided things into two pieces. There are two ways that deals close. It's either a purchase agreement that you sign and close on the same day, so a minuscule, if no difference in time between signing and closing. And then there's other transactions that have a signing of an agreement with a subsequent closing, which have an interim period. And things can happen during an interim period that are well beyond anything that people can predict. And COVID-19 is showing that. So we've kind of highlighted on this.
You know, in practice, those interim periods, people have always thought, oh, you know, it's 60 or 30 days or 90 days to close. Many times there are reasons for that, such as we have to get a bunch of landlord consents to the fact that the tenant is changing, or we need to get some approvals from government or from licensing bodies, and we have to wait. And in most cases, the concern was always theoretical. Well, of course, something could happen. A major customer could leave, or there could be a major lawsuit. But in most cases, those just didn't pan out. And of course, what we found was something completely unanticipated, which was that a pandemic that occurs during your interim period certainly can have a material impact on the business. And this is probably, of all the transactions that split between the two, signing and closing on the same day and the interim period transaction, this has opened a lot of eyes as to just how big the change can be during an interim period. If you signed a deal in February 15th, and that transaction was to close May 1st, then it's quite possible that this business has gone through an enormous transformation, even though the time period is not all that long and usually wouldn't have been anticipated to create any problems. But this is for transaction lawyers, the new normal of COVID-19.
And the interesting thing about a material adverse change clause is a focus on the part material and what is material. And a material adverse change clause, or the definition of material, is a negotiated term. And often they're broad, and one party might want to shrink how broad that definition of materiality is, and another one might make it broader, such as a purchaser to allow different things to fit in there, but it's ultimately a negotiated definition. And we're noticing for more and more transactions, people are trying to decide, wait a second, not just material adverse change clauses, but what other mechanisms can I use to kind of deal with allocating risk, and also saying, I want certain things to be present on closing. I want a certain level of, earnings or inventory or whatever it might be in this business, so I know what I'm getting on closing. I'll kind of hand it to Ian if you want to add some comments on that.
Well, the thing is, for material adverse change clause, and for many transactions, that has come up as being the focus of attention. But for a number of businesses and for transactions, it doesn't really serve as a complete form of help. So in other words, lots of businesses are still operating, and material adverse change typically talks about such things as the business has been shut down, the government has done something, there's acts of war, terrorism, an act of God like a hurricane, etc. Whereas the concept that you're only running half as many shifts as you used to because a number of your customers happen to be closed wasn't really caught by force majeure. That's not a force majeure situation. And so what we're seeing instead is, all right, we need to be a little more cautious if we're going to have interim closing periods, if we're going to have a big gap between signing and closing, and what are the ways that we can deal with that? And purchasers, generally speaking, are talking about stretching out payment terms, putting in place a deferred payment structure, and they're also looking at the purchase price adjustment mechanism, possibly to include adjustments for performance post-closing. And putting some of that back onto the vendor. So we're seeing some of those just around sort of rethinking how the transaction would work.
In our experience, we've closed a few deals in the past couple months, and we've noticed in terms of deal closing challenges and dynamics, we've shifted to completely electronic closing. So we've used platforms like DocuSign and PDF Sign for all of our documents. We've thought of things like adding flexibility in the non-shop and exclusivity period, so the amount of time from the signing of the agreement to when it has to close, working in that, it might take a little bit extra time to get those third-party consents and those regulatory consents, because we don't know how long people are operating and at what capacity. So we need to work in some flexibility at the onset to deal with those challenges. So why don't we move along to opportunities? And the more exciting part of our presentation, because I think it's safe to say Ian and I like to be optimists when we can, but we're cautious worry-warts where we have to be for you. So we'll kind of break the opportunities into 4 headings that are on the screen. And we're saying, keep an eye on these. These might be some opportunities in your business. Some being, hey, a management buyout transaction. Who knows a business better than management who's been with the business for a period of time, knows the repeatability of results, and can have a bit of more intimate knowledge about how a business may rebound in the future and its perspective. But there also might be some flexibility with respect to the purchase price or payment terms because of a personal relationship, as opposed to a third-party cold relationship. The next thing is,
and I would say this, depending on the type of business, if management or someone who is knowledgeable about the business is interested in making an offer and acquiring a business, this is probably a great time to review it, because there is definitely flexibility on purchase price and payment terms right now. The general market for vendors has softened somewhat. They're more receptive to these types of things. So if you're in a position to make an opportunistic buy like that, now is a great time to get probably the most flexible price and terms that you could ever expect.
And that kind of buttresses well with our exit opportunities point at the bottom, saying also some vendors are thinking, this is a change in my own lifestyle. Perhaps I want to look at new opportunities in my own life, and maybe there's a not transactional relationship or dynamic, but a personal one, saying, I'm ready to move on to another phase, and that could also incentivize someone to want. There is a great availability of cash. Bank rates are low now, as we can point there, and so there's accessibility to cash. You have the ability to get credit. And there may be some distressed market opportunities. It's an unfortunate concept, but it's a reality that some businesses won't make it through this pandemic. And there may be an opportunity for a person who has a successful track record of turning around businesses to step in, acquire assets to add to their current business or their business arsenal, or to step in and run a business and take it forward with a new direction. So that's something we wanted to highlight as well.
You know, we definitely are anticipating that now that at least in Ontario and really in the rest of Canada, I think pretty much the rest of Canada, people are talking about exit scenarios. We are expecting an uptick in acquisitions. And we are expecting that based on people that are cash rich and are in a position to buy, and they will be looking for opportunistic purchases. That is coming. So if you want us to tell you about the M&A world, I think we would probably, Kevin and I would tell you that probably since about mid-March till mid-April, that things were delayed. Everything was frozen, but that is starting to change, and it's something you can expect to see. For those of you that are in a position to do so, it's something you're probably already engaging in. Looking at related businesses, looking at businesses that might have always interested you, and whether or not now is the right time to buy, because we fully expect that coming out of this, of not only the pandemic, but maybe tied with it, this short but harsh downturn economically. So that's something I think for all of us to keep in mind. It's true in the business world that during these tougher times. Those that have the means, they engage in opportunity buys, and that's what they're doing.
So for the last slide, we're going to move along to being ready to go to market. But I think there's a flip side to that, saying, listen, if you want to look at the market, what are some things you might want to keep an eye on? So buttressing Ian's last point, use the time wisely. There's a chance now with a downturn in actual business activity for some businesses to focus on expansion or a contraction, and looking at strategic transactions. So some things, if you're a seller, might be getting the process started with your accountant and your lawyer with respect to some pre-sale tax planning. Hey, if you want to take advantage of your lifetime capital gains exemption, for example, we won't go into depth of what that is. Happy to talk offline about that. But how do I structure a share transaction so I can fully leverage my tax planning? Or am I deeply entrenched with my business? Is my goodwill tied entirely to me being the business owner? Do I need to start bringing on another group of people that know the business, know the relationships, know my customers in a way that I can distance myself and satisfy a purchaser that when you buy the business, it's not just my name and a potential consulting agreement that goes on, but there's a repeatability of results because there's other people in place that can carry this business forward. One thing we kind of also tell our clients is engage a valuator. Chartered business valuators are great at providing valuations, not just for justifying the purchase price, but for looking at ways to kind of find improvements and find ways to bolster your valuation. What are some ways we can improve our business, our systems, and even more systems to have repeatability of results and justify our price going forward? It'll help you attain some financial stability because you're able to show, hey, this is rock solid and it's fire tested. Try poking a hole in it.
Now, I know we're getting tight on time. I think one issue that was brought up in particular was whether or not we think that the uptake in acquisitions will be across all industries or focus on specific industries. I don't think we have time to deal with that question now, but Kevin, after the seminar, the webinar is over, we can follow up, and we'd be glad to take that conversation offline. And I think that is it for the M&A presentation, and we're going to be moving to deal with some real estate concerns with my partner Jennifer Lebrecht leading that particular presentation. And so Jennifer, I will let you take it away.
Thanks. Can everyone hear me? Can you hear my voice?
Oh, absolutely.
Okay, good, perfect. Just want to make sure there's no issues with that. Thank you for joining us today. Today I'll be covering two topics. The first one being commercial leasing and how landlords are dealing with the avalanche of rent relief requests, and also touching on both sides. If you're a tenant, how is this COVID situation impacting you? And then I'll briefly also touch on the impact of this pandemic on more of a transactional point of view. So we're going to purchase and sell, whether they're residential or commercial. So I'm sure everyone is obviously very fully aware that the COVID-19 has had a tremendous impact on people's ability to pay their rent. And so how does that translate in terms of what has happened in the marketplace? So if you're a landlord, I'm sure you've been inundated with requests from your tenants, whether they were formal or phone calls, asking, what can you do for me? And you know, landlords at first, just like all tenants, were a little taken aback by this situation and weren't really sure what their rights were. And we've received a ton of phone calls trying to assist landlords with the situation. So as a landlord, essentially what you're looking for is getting paid your rent pursuant to the lease agreement that you have in place with your tenant. That being said, many businesses have been impacted and are unable to operate because they weren't deemed essential services. So it's what I've seen in the marketplace really is it's all across the board. There are landlords that have been willing to work with their tenants, realizing that this is a very unfortunate situation, and we're all in this together. Some landlords are also tenants at some locations, so they really understand the situation that these tenants are going through. Some landlords have been able to negotiate mortgage deferral payments and maybe more willing to assist tenants through this difficult time. Some landlords may not have a mortgage to pay and may be in a financial situation where they may be more willing to assist their tenants through this difficult time. But I would say that across the board, what we've seen is that landlords who receive these types of requests, as the months have passed, the weeks have passed, have started to be, because of the amount of requests that they receive, have certainly started to request from their tenants a lot of backup documentation in order to sort through these requests and assess whether this is really a need or whether the tenant is actually asking for the rent relief or discount simply because of the COVID situation and not necessarily being in need of the relief. So what we've seen some landlord asking, it's as I said, it varies from landlord to one landlord to another, but typically most landlords will want to see that the tenants have taken steps themselves to mitigate the situation. So be prepared that they may ask you to see what have you done to, let's say, reduce your rent roll? Have you contacted your bank to see whether you would qualify for some loan? I'm not your bank type of response. Have you contacted any suppliers to extend, terms of payment on some of the accounts that you might have? They would like to see, a lot of landlords would like to see truly how that business has, how the COVID situation has impacted your business. So they may ask you for revenues, show me what your revenues were last year compared to this year. Typically, most landlords at this point are now looking for some evidence of all the measures that you've taken as a tenant to reduce your expenses. And despite all those measures being taken, still having difficulty and need assistance. So with some businesses, it's a little easier. If you've been completely shut down, you can't operate, your revenues might have gone from, you know, X to 0. But with others, it's not as easy to demonstrate what, you know, that you have been impacted. Also, there are a lot of new businesses. It may not be possible to demonstrate as a tenant to your landlord if you started your operations in January, unfortunately for you, that your revenues have declined. There's also something else that we see a lot in the marketplace right now, which is some businesses have not necessarily seen a decrease in revenue, but have issues with cash flow. So how do you show your landlord that you are in need of rent relief despite your revenues being very similar to the ones from prior years, for example? So that's a challenge for tenants, but there are ways to explain to your landlord that this is what you're dealing with this time. So from a landlord perspective, what I'm seeing is they are being bombarded with requests for rent relief or rent discount. And originally when the situation started, I think that most landlords were really willing to work with their tenant. But now that it's becoming more prevalent, you know, the landlords are dealing with the situation and are just like you, if you're a tenant, not too sure on what to do. I'll touch on the new program that the government has put in place to assist with the commercial rent assistance towards the end of the presentation. But that's an option, although not very clear at this point what's being offered. There's a lot of uncertainty regarding that program, but I'll touch on that. So in terms of what the landlords will be requesting, that's the kind of information that they'll be seeking from you as a tenant. If you're a tenant and you're on the other side, you're thinking, am I obligated to pay my rent? I have a lease. I'm not too sure what I should be doing. This, I'm not able to operate. I've been forced to close my store or my location. What do I do? To that, I say you look at your lease. Obviously, you go back to your the agreement that you have with your landlord. There might be a force majeure provision in your lease. However, in my experience, most of these provisions usually specifically do not allow for the non-payment of rent. They don't excuse the payment of rent. So most tenants are out of luck when it comes to that. But I think there is the opportunity here is that the reality is everyone is in the same boat at this time. Most landlords will want to work with their tenants with an agreement, because the reality is in this marketplace, there aren't many other tenants that are seeking space to lease, premises to lease. So except for very few types of tenancies. But so that does give you an opportunity to negotiate with your landlord. So what has happened in the marketplace, what I've seen, and you may have seen in the news, larger landlords such as, let's say, the Eaton Center, it's been reported that they in April, only 20% of their tenants have actually paid rent. So whether that was a tenant that decided not to pay rent because they are not operating, or whether that was through an agreement, that's not clear at this point. There are people in the marketplace that are not bothering with entering into an agreement with the landlord. And basically I have tenants that are saying, listen, I just can't pay. Whether the landlord will agree or not, I can't pay. I'm not generating any revenues. So obviously there are potential issues with that because you could be deemed in default of your lease obligations, and it's definitely more. I definitely recommend that you try and negotiate an agreement, a simple agreement with the landlord, to ensure that your obligations to pay rent are deferred. That's what we mean when we talk about a rent deferral. So what we're seeing is agreements that would, for example, either defer the entirety of the lease payment obligation to be repaid within the next 12 calendar months, or sometimes these amounts can be added to towards the end of the lease or the remainder portion of the term of the lease as well. We're seeing those kinds of agreements, or an entire amount, the entire amount. So whether that's minimum rent and additional rent that would be deferred towards the end of the lease. That's also something that I've seen in some rent deferral agreements that have been granted. But again, there is no perfect formula. Everyone's doing something different, and everyone is really being impacted by that. So that's for that. I can see also, not that I've seen it happen yet, but what I could foresee happening when it comes to commercial tenancies is that you, as a landlord, if you have a portfolio and you have had problematic tenants, maybe someone that is constant, forget about COVID, they're consistently late paying rent, or even maybe not rent payment, but other issues that you're dealing with the tenant on an ongoing basis. And now all of a sudden, this tenant becomes unable to pay rent for a legitimate reason on an extended period, because there is nothing in most instances that forces the landlord to work an agreement with their landlord. I could foresee that some landlords may take the opportunity to finally, terminate the tenancy based on a non-payment of rent, and the tenant not being able to come up with the rent payment. So there might be some opportunities with some landlords that have been dealing with some difficult tenants to finally get out of the lease. You might also see something that that could happen is, unfortunately, some landlords that might be more opportunistic and maybe had long-term leases, and it doesn't affect all classes of tenancies. But for example, in the industrial market, everyone knows that this market has been really trending, and rents have significantly increases over the past years. So I could possibly foresee some opportunistic landlords that could use this COVID-19 situation to because, as I said, they have no obligation to work with their tenants to come to a rent relief agreement, use the situation to terminate tenancies. Tenant can't pay the rent. I don't care, I'll get the tenant out, and probably there'll be 10 other lineup in about 2 months, and my rent, I can use this opportunity to increase significantly the rent that I can charge to the tenant. So I could see that this could be an issue for some tenants. So it's important for the tenants. I guess what I'm trying to say is, if despite a lot of tenants out there not having an agreement with the landlord to do the rent relief program, there is an incentive to do it, which is to secure your tenancy, because at the end of the day, if there are no agreements in place, you would be in default of your lease obligation, and there are some landlords that are opportunistic could take advantage of that. Of course, if you're a restaurant tenant or a retail tenant, as a landlord, probably very difficult right now to find another suitable replacement tenant, and it's probably more unlikely that a landlord would take these kinds of steps. But again, because we're having a conversation that is more generic on all types of tenancies, I think that was important that I point those potential issues in the future. So that's for that. So I will briefly touch on, as you know, there is, if you're a tenant or if you're a landlord, you've probably heard by now about the announcement that was made, originally came out on April 16 from the federal government, that it would come out with a program to assist landlords and tenants with respect to their rent. And when it first came out, we received an avalanche of questions, but it was very vague. And then on April 24th, of this year, they came out with more details about the program. And essentially, in Ontario, there is an initiative that is specifically referred to the Ontario Canada Emergency Commercial Rent Assistance. So I'll just call it the program throughout my conversation now. But essentially what this program does is the government has come out and said that they would offer forgivable loans to qualifying, and there's a lot of like definitions here, and it's very important because there's a lot of loopholes, I think, with the program, but the government will offer forgivable loans to qualifying commercial landlords to cover up to 50% of the monthly gross rent payable by eligible tenants for the months of April, May, and June. So what those loans would, how the program is intended to work, I'm told, again, still work in progress, is that it would be disbursed directly to the mortgage lender of the landlord. And it would be administered by the Canada Mortgage Housing Corporation with the assistance of all levels of government. So their deadline to apply for that program is, I believe, August 31st. And there are very set rules for the loan to be forgiven. The landlord has to agree to reduce the tenant's rent by at least 75% for 3 months. The tenant would have to be responsible to cover no more than 25% and the landlord no less than 25% of the rent. And then the federal and provincial government would share the remaining 50%. There are other details. The rent that needs to be that can be passed through the loan is only the before profit costs. So as you may be familiar, in a lot of the leases, there is an administration fee or a property management fee that is applied. Often it's a 15% fee. That doesn't seem, there's no clarity, but doesn't seem that this can be part of the loan. In addition, another requirement of the loan program is that the lender and the tenant must sign an agreement, like I was discussing before, that it would be like a rent forgiveness agreement. That agreement, lenders have to be aware that it must include a stay on evictions of the landlord. So I'll touch on that a little bit later. Commercial landlords that have not offered the reduction for April and May can do so retroactively. The landlord must comply with all the terms and conditions of the program, and there's quite a few. And then if we want to look at who's an eligible landlord, because I think that's important, landlords who are registered owners of commercial real property in Ontario that generates rental revenue. So I'll touch on that. If you own a property through a nominee agreement, for example, or a trust agreement, you may not qualify for that program. Landlords of commercial properties with a residential component and residential mixed-use properties with commercial tenants are also eligible. However, the property must include at least 30% of commercial component to be eligible. Landlords who have a mortgage loan secured by a commercial real property, basically, if you do not have a loan, if you do not have a mortgage at this point, you may not qualify for the program. Apparently there is going to be an announcement, and there might be another program or some other way to qualify, but at this time, my understanding is that you do not qualify if you do not have a mortgage. And you must have declared rental income on your tax return. And then in order for you to be an eligible tenant under the program, you must be paying less than $50,000 per month in gross rent. You must have temporarily ceased your operation or experience a drop of at least 70% in revenues. And the $50,000 monthly rent cap applies per location, and not, let's just say you have multiple locations. As long as you don't generate more than 20 million in gross annual revenues, you might be able to qualify. There are some exclusions, but I'm not going to touch on those because they're, I could have a conversation for 2 hours just on this program. But one of the main exclusion is if you, as a tenant, were already in a special account or restructuring type of situation, you probably do not qualify for the program. So this program brings up a lot of questions, and I don't want to touch on it too much, but if you have specific question about the program, I'll be happy to answer those questions. But some of them, as I said, what happens to landlords who do not have a mortgage? What happens if the total applications for the programs, because we can imagine how many applications there will be, exceeds the funding for the program. No, there's no clarity on that at the moment. The $50,000 of rent, is it inclusive of HST or not? What happens to HST if the rent is forgiven? If you're dealing with a franchisor type of situation, who's on the lease? Is it you, meaning the franchisee, or is it the franchisor that has multiple locations under that corporation? Because $20 million in revenue in that situation could easily be reached, right? And so there's a lot of question and uncertainty still with respect to the eligibility of the program. It looks like it's going to be the landlord that must apply. Not too sure who's going to make sure that the tenants are actually eligible for the rent relief. Whose obligation will that be? But that's a quick, and I think I've run out of time.
I think you have, but it's this is one of the topics that have been of most interest for our clients at this time, both tenants and landlords. For anyone that has any additional questions for Jennifer, please feel free to reach out to her directly, and we'll do our best to help you out, both with the concerns and also with, unfortunately, the complexity and, to a certain extent, the fact that the legislation itself really isn't finished yet. But we'll help you through it. And now we're moving on to have Gideon talk to us again. Real estate sort of focused, but as opposed to landlord tenant, we're going to talk a little bit about new home construction and how this has been impacted by COVID-19. So Gideon, please take it away.
Thanks for the introduction, Ian. Everyone can hear me okay?
Absolutely.
Okay, great. So it's a pleasure to be speaking to everyone today over Zoom in these interesting times. My name is Gideon. I'm an associate at KMB. My primary practice area is assisting developers and builders with residential, commercial, industrial development projects, including purchases and sales of various types of property, land assembly, title conversions, and helping to secure planning approvals and municipal approvals and permits for condominiums and subdivisions. So today I'll be touching on 3 relevant topics in the new home construction field. Firstly, I'm going to just briefly update what the market is looking like right now for new home construction, both from the purchaser side as well from the seller side. Secondly, I'm going to deconstruct the process that builders and purchasers are taking to extend or delay occupancy closing dates as a result of shortages in suppliers or contractors. Developers and builders are looking at opportunities to delay closing dates due to their inability to meet construction timelines. And lastly, I'm going to just have a brief conversation about pre-delivery inspections and carry-on warranty claims in the context of this COVID world. So here's our disclaimer. So starting off with the market outlook, I got some information from the Building Industry and Land Development Association. Numbers for March were actually very good, which is not surprising given COVID-19 lockdowns didn't really start till the second half of that month. But new home sales were up 67% over and above March 2019, which was very promising. This was standing to be a really great year for new housing sales and inventory. Lots of developers and builders were planning on launching their projects. New housing construction is a very large part of the Canadian economy. So I did look briefly into April 2020 numbers. It's looking pretty bleak in terms of both number of sales and inventory. That's just a result of builders and developers delaying their launches and the general kind of fear of leveraging or risking yourself too much at this time. One really interesting thing that I'm seeing with this COVID-19 process is builders are starting to look at new opportunities to get their product out there. That includes embracing new types of technology to market and get their product out to the marketplace. In particular, I'm seeing some builders turn their websites into basically into sales centers where they're offering virtual and interactive tours of computer-generated home renderings, offering the opportunity for purchasers to even view 3D floor plans, switch and play with interior design and exterior features, and even see how their furniture fits into a room. In my opinion, if there's any type of housing that can really weather the COVID-19 situation, it's new home construction, simply by virtue of the fact that most new home sales occur before anything has even been built. So, so purchasers are already kind of going into their purchases just simply based on computer-generated images and plans about the construction. So developers are definitely looking at new ways of selling product in lieu of the traditional sales launches and presentation centers, which have been characteristic of the industry lately. So if people were here at 9 a.m., Iris touched a little bit on this discussion already regarding the limitations on residential construction. In particular, residential construction can continue for a number of projects. One where a footing permit has been granted for single family, semi-detached or townhomes. In the context of a condominium like your high-rise 40-story condos, those are permitted as long as a structural permit has been granted. And lastly, projects that involve renovations to residential properties and work was started before April 4th, 2020 can still continue. So things have still been fairly busy. Where the delay is likely to occur is projects that are still in the pre-construction stage or undergoing servicing before any kind of foundations are put in place. Those are where you're going to see the big delays. There was a welcome step towards normalcy on May 4th, and the housing industry is very excited that they can get back to work on necessary excavation work, grading of roads, and installation of utilities. So those type of activities are now considered essential. The season in Canada, unfortunately, is very short for this type of work. So the ability to get this work done now between pretty much April to October is key. So this change was welcomed by the industry. So now I'm going to move on to kind of the meat of my presentation, which is discussion of the Tarion Addendum. The Tarion Addendum is a document in a prescribed form that the Tarion New Home Warranty Program puts out and requires every builder to include in their agreements of purchase and sale. The provisions of this addendum supersede any provisions in a project of agreement of purchase and sale between a vendor and a purchaser. So if there's any inconsistency between a Tarion addendum and the form of agreement that has been provided by the vendor, the provisions of the addendum will overrule. COVID-19 has forced builders and their lawyers to look very closely at this addendum and to look at the opportunities for them to either extend or delay occupancy dates if it's required in order to provide delivery of the new home. Especially when you're purchasing new homes as well on the purchaser side, it's really important to review this document because it does contain important information about the procedures and ways in which a developer may extend or delay closing. And there are also early termination provisions contained in this Tarion addendum, which explain the situations in which a developer can cancel a project or terminate an agreement of purchase and sale. In that situation, a purchaser would get their deposits back and the agreement will be at an end. Now, what we're seeing particularly in the market right now is purchasers in projects that are near completion are only seeing very short delays in their occupancy dates. This is mostly as a result of supplier and contractor shortages and having to move people around the work site to make sure that occupancy can be granted, moving them away from kind of projects that, or parts of the site that are far away from being finished towards parts that are close to being finished. Purchasers, in contrast, in newer projects on sites that are not yet under construction or there's not physically anything out of the ground, may see much longer delays, upwards of 6 to 12 months, depending on availability of resources to do the earthworks required to kind of get the buildings off the ground. Some purchasers who may have purchased units in a condo, for instance, in February and March, may see their projects completely canceled and the project not going ahead simply because the developer may not see the economic feasibility in going forward with the project at this time, or may not be able to secure the necessary resources or contractors to actually meet the timelines. So be cognizant of those early termination conditions, especially if you are in the market for purchasing a new home at this time. So I put together this handy little chart, and I'm just trying to get to my notes here. Okay, so this chart deals with the ways that a developer or builder can extend or delay an occupancy closing. Every Tarion addendum has a statement of critical dates, which is typically the second page of the Tarion addendum, and it lists the dates in which the builder will provide occupancy of the home. So when entering into a purchase agreement with the builder can set either a first tentative occupancy date, or if the roof has already been constructed or completed, they will set a final tentative occupancy date. And in some cases, if you're moving into a new home that's pretty much already complete, builder may set something called a firm occupancy date. Builder also needs to set an outside occupancy date. This is the date in which the latest date the builder can provide occupancy without triggering a right on the purchaser to terminate the purchase agreement. So a builder has a few options to legally delay or extend closing. And I've done this flow chart so you can kind of see and follow me as I go through these timelines. So the first tentative occupancy date can be moved as much as possible at the discretion of the vendor, provided that this option is exercised at least 90 days prior to the occupancy date. If it's not, if the vendor doesn't send out notice to the purchaser within 90 days, then that date becomes the firm occupancy date. The final tentative occupancy date may be extended or delayed at the vendor's option upon at least 90 days notice to the purchaser, but only for a maximum of 120 days. That date, which is 120 days later, becomes the firm occupancy date. And then if it's not extended or delayed upon mutual agreement between the parties, delayed closing compensation is paid. So lastly, the more complicated situation for builders and purchasers right now is if the occupancy date set out in your agreement is a firm occupancy date. A firm occupancy date can be changed in one of three ways. Firstly, a vendor can set a delayed occupancy date, which is a date that the vendor will unilaterally set and tell the purchaser that, hey, your house is not going to be ready by the date we indicated. You're entitled to delayed closing compensation. Delayed closing compensation is a maximum of $7,500 or $150 per day, whichever is less. Typically, the builder will pay the delayed closing compensation as an adjustment on final closing. However, some builders request that purchasers actually make that claim directly to Tarion after closing. The second way a firm occupancy date can be extended is through a mutual agreement to extend. The Tarion Addendum sets out very clear guidelines about the form of this amendment. Typically, this is beneficial if purchaser needs more time to secure their mortgage approval, or they're selling their house, for instance, and it hasn't sold yet. And the builder as well needs time to meet the construction deadlines. Lastly, I'm going to talk about the unavoidable delay, and I'm sure most people in the real estate field will be familiar with this because it's received a lot of attention in the context of COVID-19. The unavoidable delay is defined in the Tarion Addendum as an event which delays occupancy, which is a strike, fire, explosion, flood, act of God, civil insurrection, act of war, act of terrorism, or pandemic. So this also includes any period of time that is directly caused by the unavoidable delay. This is referred to by Tarion as the remobilization period. Tarion is accepting unavoidable delays for the full length of the provincial emergency, as well as 30 days for remobilization, which is the time it takes the builder to kind of reorganize its construction workers and its suppliers in order to meet the new timelines. There's a specified way to exercise the unavoidable delay provisions. If a builder is going to unilaterally delay by virtue of the unavoidable delay, there's a requirement that the builder send out 20 days notice to the purchaser, advising of the reason for the delay and the estimate of time for the delay. Now, this 20-day notice must be provided 20 days after the builder reasonably determines that they're going to be unable to make the occupancy date. So there is some discretion. Typically, Tarion is looking at this situation as if the pandemic was declared, for instance, on March 11th or March 15th, I believe it was, in that situation, if the builder determines by April 5th that it's going to delay closing, they can still exercise the unavoidable delay. Now, once the builder determines that the unavoidable delay has ended, they need to send out a second notice to all purchasers that are impacted, setting out, again, the description of the delay and provide new critical dates. The critical dates will be, or the extension for the unavoidable delay will be equal to the period of the unavoidable delay plus the remobilization period, which is then added on to the firm occupancy date. So if you had a firm occupancy date of May 1st, for instance, and the unavoidable delay was 120 days, you're entitled as a builder to 120 days after the date in which the firm occupancy date was to occur. It's important to know that builders should be very cautious about sending out a notice ending an unavoidable delay, because Tarion only allows you to use one unavoidable delay once. You cannot use the same unavoidable delay reason to then send out another unavoidable delay. So it's very important that builders know for sure that they're going to be able to make these dates. Otherwise, they're going to be liable for delayed closing compensation. So I think I have about 5 more minutes. So I'm going to briefly discuss the pre-delivery inspection process as well as Tarion warranty claims. The emergency order that was passed on March 16th extended limitation periods under any statute, act, or rule, or bylaw, or guideline set out by the Ontario government. So this did impact Tarion warranty claims. So what Tarion has advised purchasers and builders is that all warranty claims submissions by homeowners are suspended, giving owners of new homes more time to submit their 30-day year-end and second-year claims. And COVID-19 is also impacting repair timelines. So repair timelines are suspended. So typically, builders are required to go into a home and complete deficiencies in a specified amount of time. Those timelines have been suspended, and homeowners also do not need to provide developers access to their units or homes at this time to complete deficiencies, which typically a homeowner is required to allow contractors and suppliers into their house to complete repairs in order to fill the Tarion requirements. Lastly, mentioning PDIs, pre-delivery inspections are completed prior to delivery of a new home. And in particular, this is an opportunity for the purchaser and the builder's representative to review the home and see if there are any deficiencies. It's important to note that the PDI form is not a carry-on claim form. So what builders are now doing for PDIs is telling purchasers that they'll complete the PDI on their behalf, note all deficiencies, and then purchasers need to go into the home after closing and note any deficiencies or issues on their carry-on claim form, and then they'll submit that for 30 days on their 30-day carry-on claim form. Pre-delivery inspection is probably going to change for a long time. I'm thinking at least 12 months this procedure will be in place where the builder and purchaser don't inspect the home together. And this is Terrion's guidance just to ensure health and safety at this time. So in conclusion, my presentation was just a taste of how COVID-19 has impacted the new home construction industry. It has also had a significant impact on condominium governance as well as municipal approvals and processes. And I've seen that become a big issue in my practice as well. So if you have any questions, I'm not sure how much, we have a couple minutes. If you have any questions, I will be here to answer them. And if we can't get to them during this time, then you have my information. Feel free to reach out to me. Thank you.
Yeah, I think, Gideon, I think we're running tight on time, but if anyone does have any questions, please feel free to put them in the chat or the Q&A or email Gideon directly, and he'll be glad to get back to you. And we'll be moving on to Anne. Anne is going to be speaking to us a little bit about what's going on in real estate financing, giving an update based on how things have been impacted with what's going on with COVID-19. So welcome, Anne, and I'll let you charge ahead.
Great, thank you. Good morning, everyone. As I was introduced, I am an associate in our real estate team. I work on residential and commercial purchases, sales, and financings. I also work in the area of real estate development. I'm here to discuss the market trends and options in financing for businesses during COVID-19. As we all know, it has put a massive strain on businesses at this time during the last few months, which has affected the cash flow and businesses' ability to obtain new financing. Some borrowers have been left to request short-term deferrals on existing loans. In these cases, developers may still require the borrower to pay certain expenses like realty taxes if it is a mortgage that's secured by real estate, operating costs, and perhaps some part of the mortgage. For borrowers looking for new loans, such as individuals looking to refinance their properties to take advantage of the equity there, lenders may be requiring new requirements that weren't required before, such as minimum cash flow proof, minimum borrower capital and liquidity, and more financial reporting. One interesting aspect that has changed a little bit is that now the financial strength and future of tenants is more important to lending as it relates to the property's ability to generate revenue during this time. Lenders are also being faced with property valuations that are difficult to determine, which will likely affect their loan-to-value calculations. However, if borrowers are in this situation, what we recommend is that you work with your financial institutions when requesting changes to existing loans or when you're obtaining new financing. Some of the things you should have ready to provide now are rent rolls, property operating statements, and net worth statements during these discussions. You should ensure that any changes or particular requirements are properly documented and that obligations for both sides are continued. There also has been an increase in private lenders in recent years, so that might be an option for some borrowers looking to obtain financing in a quicker way, but they might get that benefit in exchange for higher interest rates. So that's something to compare when you're looking at different lenders. And as for options during this time, the government in Canada has introduced some programs to assist businesses during this time. So The first one is the Canada Emergency Business Account. It provides interest-free loans of up to $40,000 to assist operating costs of small businesses. If you repay this balance before December 31st, 2022, there will be a loan forgiveness of up to $10,000. Businesses need to show that they had between $50,000 and $1 million in total payroll in 2019, so there's certain requirements that you need to meet. This is provided through eligible financial institution in cooperation with EDC and BDC. We also have the business.
As I understand it, and for that one, so you apply directly through your financial institution, the particular one, whatever it may be. They're not requiring additional security. It's just a loan application process, as I understand it. Is that right?
That's my understanding too.
Okay, so no additional security, and as long as you stay on target, if you borrowed the full 40,000, you actually get a forgiveness, which I'm sure would be taxable, but still you get a forgiveness of 25%, 10 grand.
Yeah.
Okay.
Yes. So it's a nice option for a business is looking for that kind of amount at this time. The next one I was going to discuss was the Business Credit Availability Program. It offers up to $12.5 million through 2 streams, and it's through a small and medium-sized enterprise loan guarantee program. You could receive up to $6.25 million in loans. The way it's broken down is $5 million is provided by BDC, and $1.25 million is provided by the financial institution. You can also get up to $6.25 million in operating credit and cash flow loans, and 80% of that is guaranteed by EDC. So you see this working of different institutions to try to provide these options. To be eligible, businesses must have been impacted directly or indirectly by recent events and have been financially viable prior to COVID-19. Again, you can ask your financial institution for these options. They will contact BDC and EDC and work with them where appropriate. And BDC also provides a line of credit of up to $2 million in working capital loans. The first 12 months includes payments of interest only. Up to 40% of the loan will be repaid over the next 2 years. And they provide these options at favorable interest rates. And then we have the Canada's Emergency Wage Subsidy, which can assist businesses' payroll needs as well. It provides a subsidy of 75% of employee wages of up to 12 weeks on the first $58,700 earned by an employee, and they provide up to $847 a week. So this can really help people at this time. And it is retroactive from May 15th to June 6th for 3 months. This is available for employers of all sizes and across all sectors who may have suffered a drop of gross revenue of at least 15% in March, 30% in April and May. This is provided through the Government of Canada as well. So those are the main options that we have during this time. So the lenders are working, with people right now to try to work through the risk and see the requirements. And there is this dialogue that we're seeing. It will be interesting to see what new requirements will be coming up shortly as well. I can answer any questions.
My understanding is there's been a pretty significant backlog, though, with the banks as far as getting these types of loan applications processed. Is that correct?
That is correct. So we see them in underwriting right now, and we expect to see some movement in the next few months as loans are getting approved. So we encourage people, if they are having these discussions, if they need to talk to their legal counsel as well to get some advice, to do so at this time too. But we do see that. So it'll be interesting to see if there'll be a shift to private lenders during that time, if they're going to be quicker in that situation.
It's my understanding that the $40,000 loan program that you talked about at the beginning, that is very quick, which is great for those who can use it. But for anyone who is looking for more significant funding, Unfortunately, the rest are pretty delayed. So that means you can apply now, but you really need to you need to plan for how to deal with your business in the interim period, even if you do qualify, because that funding is not going to be in place for, is not going to be advanced to you for a while.
Mm-hmm. That's correct.
Okay. Okay. Now, I think on our end, we've talked to a lot of banks about these about the financial situation lately, and my understanding is that they're speaking to all their clients. They're getting a lot of communication from their clients, but they're also many of them have been pretty swamped with these applications. So it can be difficult to get any type of a quick answer. So unfortunately, we're kind of all in the same boat, but the idea seems to be that the financing options that have been introduced, they're available. I think, and you point out some of them are quite significant. It's a,
Mm-hmm.
you know, a material funding amounts, material financing amounts, but the delay in the process, you know, that part hasn't been solved. I don't know. Have you heard anything on a process side that they're doing or can do to speed this up?
You're right. As we all know, banks are really feeling the pressure right now, right? They're getting a lot of requests, and the staff might be really, you know, spread thin at this point too. So we're being asked to be patient and work with everybody. I haven't heard of any particular processes that are in place yet, but we have been working with them to get some movement in this area as well. But I'm sure, you know, things are changing all the time on processes, and we're, you know, working with them on that front.
I also find it interesting when a long time ago, when I started practicing and did a fair amount of financing work at that time myself, that the relationship between BDC and different financial institutions was, I think, more common than it is now. That there was a lot more partnership where the financing was basically joint. You know, and that could be operating line from Schedule A bank, term loan from BDC. That could be term loan from a Schedule A bank, but the bank wasn't comfortable funding the full amount, so it was backed up by a subordinate loan from BDC. That was a much more common, you know, 20, 30 years ago. And then over time, that dissipated a little bit. Whereas now we're seeing with the plans, you know, in a number of cases, that the federal government at least is using the BDC in part as its financing arm to roll out these programs. Sometimes the BDC working on its own. Again, sometimes with BDC working with the Schedule A banks. So it's a little bit of a, for those that have been around long enough, it's a little bit as if we're going back in time when BDC really was really a funding arm of the government, and even though it's been separated off to its own crown corporation, etc., it's back to being the federal government's funding arm in these programs. And so, I know for many of our clients, they've been initiating contact with BDC when they really haven't had much to do with them for 10 or more years.
Mm-hmm.
So that's interesting as well. For funding options, you know, it's the government has very much focused on BDC and funding through Schedule A banks, not alternative lenders, as an example, not secondary market lenders. It's been the BDC and the Schedule A banks.
Mm-hmm.
So it's been very traditional. I think we have a few more minutes before we switch over. We've talked a little bit about some of the things that are going on with regards to financing. For those of you that have looked at the programs but have not had the ability to apply to the existing programs, obviously you can talk to your traditional lenders We have heard a lot from traditional lenders. The new programs propose for Schedule A banks, they propose some challenges, but one thing that we have heard is flexibility from our Schedule A banks with regards to extending your current funding. And so that has definitely become a common theme and something much more easy to implement. Now I see that we've got our next presenter on, Wojtek, and so for any of you that have any questions or concerns that you want to take up on financing issues, please feel free to reach out to Anne directly. We'd be glad to help out. But we can turn to our next presenter, Wojtek, and can talk to us a little bit about what's going on in insolvency and bankruptcy and proposals in this time.
Sure. So what I'm going to talk about is kind of the other end of what Anne was talking about. Anne was talking about how you get more money to fund your operations. I'm going to talk about what you do if you can't manage with the debts that you have. And if I'm going to try to share my slideshow, and if all goes well, it will work. Bear with me. Tested it before, but of course it's not working exactly now.
There we go.
Is it working?
Yes.
Wonderful. I can't see it for some reason. Well, that's unusual. All right, well, we'll try and go along. So what I'm going to talk about are two things. First of all, is that the disclaimer up on the screen, Ian? I want to make sure as I'm going through. Excellent.
Disclaimer's up on the screen.
So this is the important thing. This says I can say whatever I want to. Nothing I say can be used against me, and you have the right to a lawyer, preferably one from community law. Now moving on. So here's what I'm going to talk about. First part is going to be forbearance agreements, what they are, how to use them, what the risks are. And then the second portion is going to be if your forbearance agreement fails, what are the reorganization options that are available to you? So what's a forbearance agreement? Well, a forbearance agreement is an agreement with your lender to have your lender not enforce even though they're allowed to. And generally it happens when you've breached the agreement and your lender just wants you out the door. What's a bit unusual, what we're seeing now, is forbearance agreements in circumstances where there isn't a breach, but the lender knows the situation is tough and they're loosening the payment terms, or they're doing something around the payment terms just to let you ride out the current situation and then to ramp back up. So that's what it is. Now, what are the common terms? Well, the most basic one that you're going to want as a borrower is reduced payment terms, or somehow affected payment terms, so that you're able to deal with your cash flow and deal with the payments you have to make to your bank. Next, what we often see in forbearance agreement are various acknowledgements. The acknowledgements are usually going to relate to how much is owing, so that there's an agreement on the amount that's outstanding to your lender. But in addition to that, what you're going to see are acknowledgements around the loan documents, that they're valid, that the security is valid. If there are guarantees, acknowledgements from the guarantors that the guarantees are valid. And all of this is to give the bank some security that you're not going to be able to argue against these guarantees at some point in the future. Another provision that we often see in forbearance agreements are additional reporting requirements. It's not unusual to report to your lender, and it's usually done on an annual basis. You send over your financial statements, and that's it. During a forbearance period, what you'll usually see is instead of reporting once a year, you're now reporting at least on a monthly basis, and sometimes even on a weekly basis. And this gives the bank information about what's going on and whether they want to continue to forbear or what they want to do about your situation. Capping facilities. This is something that happens more often when there's an actual default and the bank wants you out, but the bank doesn't want to make the situation worse. So during the forbearance period, however much you borrowed to date, that's the amount it's capped at. You can't draw any more, and if anything is paid down, you can't draw back up again. Additional guarantees for security. What we're starting to see now is during the forbearance period, If you've got no guarantees in place, the bank is going to start to ask for guarantees either from individuals behind the corporation, or if there's a parent company that owns the real estate that the business operates out of, guarantees from these entities. What we're also seeing is if you've got a guarantee that's capped at 25 or 50% of the loan amount, that's now being increased sometimes up to 100% of the loan amount. Additional security can also be in the form of mortgages against a house. Again, if there's a parent company that owns other assets, security against those assets, and all things to give the bank some extra, or your lender some extra security while they're giving you more time to pay. Forbearance fees, usually not a huge factor in these agreements, but lenders will usually ask for some amount of money, and that's to defray the lender's cost of entering into this agreement. Sometimes it covers their professional fees, but it also covers their internal fees of having somebody deal with the extra time negotiating this new agreement. And then consents to judgment and consent to the appointment of a receiver. These, again, are more common where there's a breach and not in this COVID type situation where your lender is just giving you more time. But what this is you're agreeing that if there's a default, either you fail to make payments on an ongoing basis, or at the end of the forbearance period, you fail to make payment, you don't get new financing, you can't pay the bank out. They don't have to go to court and argue about appointing a receiver. You've already agreed that a receiver is going to be appointed to shut down the business. Or you've already agreed that there's going to be a judgment against guarantors or the company. What are the risks? Well, the first risk is there are higher costs in the long run. You're reducing your payments short term, but that means if the amortization period isn't increased, that means at some point in time, those payments are going to increase. So you're giving yourself breathing space now, but it's going to be a bit tougher down the road. If interest payments are being waived, well, that's not going to be a freebie. They're going to be capitalized. So they're added to the loan amount and you're paying interest on top of that interest. And then you may be faced with balloon payments at some point to deal with catching up on what the loan amounts are. Increased guarantees are a risk where in the past you weren't personally on the hook for this amount, you now are, or where you were on the hook for only a portion. It's now more than that. Additional security is the same idea. There are assets now that are at risk. Time spent on additional reporting. This is something that I don't think anyone really thinks about, but as I mentioned, it's common to have reporting requirements. Those requirements are usually on an annual basis. So you've got financial statements that you're preparing anyway that you're then sending over to the bank. Well, now you have to, on a monthly or sometimes even on a weekly basis, prepare a report that's satisfactory to the bank and send it over. And that means instead of spending time on your business, you're now spending some amount of time preparing these reports to send to your lender.
I think it's also important on that, Wojtek, it's also important to note that on that, for smaller businesses, the bank isn't going to say, send us over your reporting. What the bank will be saying is, send us over the reporting we require in the form we require it to be. And if you're a small business, you may actually need an outside resource, whether it's, you use an accountant from time to time or et cetera. You may have to have them assist to prepare these reports and deal with them. So it can be not just extra time. It's quite possible if you're a small business and you don't have that sophistication in-house, it's going to be extra money. And it will be a lot of extra money depending on how often they ask you to report. If they're asking you to send in weekly reports that you can't really produce to their requirements internally, then you're going to be on a weekly basis paying for the resource to prepare those reports. So sometimes clients forget that the reporting itself can also be a significant extra cost.
Yeah, that's absolutely true. Yeah, it's both the time and the expense of the reporting. And the last risk is you're losing a number of rights if you want to dispute enforcement. As I said, part of any forbearance agreement is usually acknowledgments around the amount of the debt or the validity of security. One of your responses, if the bank wants to enforce, is to say that they've got the number wrong. You can't argue that now. Or that the security isn't valid. You can't argue that now. More importantly, if you've consented to a judgment or if you've consented to the appointment of a receiver, you can't raise these arguments anymore. That's a done deal. In a recent situation we have now, we're dealing with a borrower that potentially would have an argument that even though they defaulted, a receiver wouldn't be appointed. And it's a risky argument to make, but it could happen in this environment. And one of the things the lender is pushing for is that consent, because they don't want to have that fight. And if you consent to the appointment of a receiver, you've given up that. So those are forbearance agreements. Now, if your forbearance agreement doesn't work out, if everything goes wrong on that end, the only other option is a formal restructuring of one type or another. And they generally fall into 4 categories. You've got a bankruptcy, a receivership, a proposal, or a restructuring under the Companies Creditors Arrangement Act. And to various degrees, these can be used to restructure a business. Let's talk about a bankruptcy first. What is it? Well, in a bankruptcy, the claims of all unsecured creditors are stayed. All the assets of the debtor vest in the trustee in bankruptcy. So that means nobody can sue the business, but at the same time, all the stuff that the business owns is now owned by the trustee in bankruptcy. The trustee in bankruptcy is going to market those assets, sell them, and pay off the creditors. And sometimes they will market the business as a going concern. Usually it's just a matter of marketing the assets and unloading the assets themselves. How can this be used to restructure? It really generally is used to shut the business down, but it can be used to restructure. The principal of the business does have the right to buy those assets. And if anybody knows the true value of those assets, it's going to be the principal. So you have the right to bid like anybody else. And if you're the highest bidder, you get to buy those assets. And if you buy them, they're not subject to unsecured claims. They're still subject to secured claims, but they're no longer subject to any unsecured claims. What are the disadvantages of this process? Well, the main disadvantage is it's not really meant for restructuring. The debtor loses control of the business. As I said, all the assets vest in the trustee. The trustee takes over. And the other disadvantage is it only deals with unsecured creditors. And what you're probably interested in dealing with are your secured creditors. Now, receiverships are intended to deal with secured creditors. And generally, secured creditors use a receivership when they're trying to enforce. As I said, one of the terms of a forbearance agreement is usually a consent to the appointment of a receiver. What the receiver does is the receiver steps in, takes over the business, and markets the business usually as a going concern in order to sell it and recover money for the secured creditor. Now, a receivership stays both secured and unsecured creditors, so it does solve some of the problems of the bankruptcy. How can it be used to restructure? Well, kind of the same way as a bankruptcy. As the principal of the business, you have the right to bid and you can buy the assets. And if you buy the assets, they're no longer subject to any creditor claims. What are the disadvantages? Only a secured creditor can appoint a receiver. So if you've put money into a business, you should have security and you should have the ability to do this. But if you haven't set it up this way, you need to find a secured creditor who's going to participate with you, cooperate to appoint a receiver. The other disadvantage is you lose control of the business same way as a bankruptcy. So it's not the ideal way, but it is an option to deal with restructuring. And realistically, it means you still have to deal with those secured creditors. They're not just going to walk away. The next option I want to talk about is a proposal. Now, proposal is more designed for restructuring. It can be used to deal with both secured and unsecured creditors. So if the proposal is made to both, then both of their claims are stayed. Nobody can enforce on their security. Nobody can sue you. Everything stops. The debtor remains in control of the business. Nobody's taking over the business. There is something called a proposal trustee that's appointed and that monitors the business, but they're just looking over your shoulder to make sure that nothing untoward is happening. And then the way the process looks is the debtor makes an offer to the creditors to pay them over time, and that payment usually comes out of revenues on an ongoing basis rather than the sale of the assets. How can it be used to restructure? Well, it's actually designed to restructure. As I said, the whole point of making a proposal is that you make an offer to all of the creditors, and if that offer is accepted, it settles all the creditors' claims. During this process, you also have the ability to disclaim or to terminate undesirable contracts. So if you've leased too much property, you can get rid of that. If you've leased equipment you no longer need, you can get rid of those leases. On the other hand, you can stop third parties from terminating contracts. So if there are contracts you want to keep, but somebody wants to walk away from, again, a favorable lease of equipment or real estate, you can force them to continue leasing to you. And the last thing that's a really powerful tool in a proposal is what's called debtor in possession financing. You can sometimes borrow money, and that money ranks ahead of any secured creditor. So if you're having trouble getting financing, it's much easier if you do it where the lender now ranks first. It's a possibility, it doesn't always happen, it requires an application to the court, but it is an option. What are the disadvantages of a proposal? Well, first of all, it's subject to very tight timelines. From when you start the process to when you have to have your proposal ready and voted on by your creditors, you start with a 30-day stay. So as I said, your creditors are stayed, they can't sue you, but that window is only 30 days. It can be extended. It's extended in 45-day segments to a maximum of 6 months. So in total, from when you start the process to when you have a proposal that's ready to go to all your creditors, you only have 6 months. And it may sound like a lot of time, but it's actually quite difficult to pull all of this together in sometimes even 6 months. The other disadvantage is your creditors have to agree. This isn't something you can force on them. They get to vote on it. And if they vote against it, the creditors vote against it, the debtor is automatically bankrupt. The vote is a majority in number and 2/3 in value. So if you've got a huge creditor and small creditors, the huge creditor can't rule the day. But you also have to keep them on board, because if they're more than 1/3 of the value, they essentially have a veto over your entire proposal. The last thing I want to talk about is the Companies Creditors Arrangement Act. I'm not going to go into any great detail about this because it probably doesn't apply to most people. This is what's used by large companies to restructure. Target, the automotive companies recently. Air Canada seems to do one of these about every 5 years. But it's similar to a proposal. The debtor stays in possession of the business, operates the business, and attempts to restructure, turn some debt into security, into shares, pay some debt off at a compromised amount, and other such things. How can it be used? Well, that's what it's meant for. You create a plan, you sell it to your creditors, they vote on it, and if it's successful, then that is your plan, and you move forward from there. The process is much more customizable, so it's better for large companies that have much more complicated issues. What are the disadvantages? Well, first of all, you need to owe $5 million to qualify to use this process. If you don't owe $5 million, you're not allowed to use the CCAA. The second disadvantage is it's an expensive process. It's very customizable, but it also means it costs a lot of money. You're not subject to the tight timelines of a proposal, but a proposal really sets out in the Bankruptcy and Insolvency Act what the process looks like. This doesn't. You make up the process as you go along. So I like to compare it to a custom suit compared to an off-the-rack suit. Custom suit is going to fit you a lot better, but it's going to cost a lot more. And that is everything I have to say about those things. If there are any questions, I am more than happy to answer them.
I have a couple of questions. The first one is, what have we been seeing lately? And so, Wojtek, you and I have talked, I think, about two things. One is we've certainly seen more bankruptcies than we have over the last few years. In addition, I think we've seen more what I will call strategic insolvency or bankruptcy processes than we have in quite a while. First of all, the bankruptcy part is very straightforward. To me, there's just been more bankruptcies than there have been in quite a while. But what have you seen in the way of strategic bankruptcies and proposals? What have people been doing or considering?
Yeah, so in the past, up until really beginning of this year, it was fairly simple to borrow money. So whenever anybody ran into problems They would just borrow more money. Houses were going up in value, so it was easy to leverage your house to pay into the business. If things weren't working, it was easy to get new financing just to keep the business moving forward. Now that's not an option. So people have to do things to restructure businesses. So what we're seeing are companies that are laying off employees and using proposal processes to pare down the business. I've been dealing recently with a matter, a cannabis company that really should not be functioning at all, operating at all, and it's finally been shut down. But is using a CCAA to try to borrow more money to fund its operations, essentially to get off the ground. We've been trying to get off the ground for years. So what we're seeing more and more is companies that are availing themselves of these processes because they can't borrow money just to fund an operation that doesn't work. They actually have to restructure their debt.
I certainly have seen as well situations where companies have had problems that they have not wanted to address for quite a long time, or alternatively, they were looking to address over a long period of time. And with this drastic change in the way they operate, that it has forced them to reevaluate, and instead of going for the long-term process, we're overstaffed. And we need to get rid of some employees, but you know what? It's going to be very expensive. Or we've got too big a facility, and we've never been able to fill it. And the next time it comes up for renewal, we should probably downsize it. Many different issues, but now they've been brought to the fore, and people are looking at insolvency mechanisms to say, you know what? Maybe now's the time to fix it because we can't live with them anymore. Whereas before, the business was doing well enough that we could live with it. It wasn't optimal, but we could live with it. And so we definitely are seeing, people turning their minds to filings because the business may need it, but at the same time, the filing is also dealing with issues that may have existed before and should have been fixed then, and we might as well fix them all at one time. We're seeing that type of thing too.
Yeah, that's absolutely right. When business is booming, it's easy to ignore the problems. If your rent is a little bit too high, that's okay because you're making lots of money. If you're paying too many employees, that's okay. If your cost of goods is too high, that's okay. It all sort of works itself out. Whereas right now, everybody's paying a little bit more attention. Your bank, before your bank is going to enter into a forbearance agreement, or lender's going to enter into a forbearance agreement, they want to make sure that you're operating as lean as you can. So they may require you to pare down the operations before they're willing to give you more growth.
And I would also say that something else that has become a part of my practice. Many business owners are now going back and revisiting whether or not they've been lending money to the company and whether or not they have taken security for their loans. Because if you have been lending money into the company, or if you have been moving money up to your holding company and then lending it back down for use in operations, having security, even if it's security behind the bank, is an extra level of control. It's a very important level of control and much more effective in some cases than just being the shareholder. Being the first or second, the primary or secondary secured creditor is a very important leverage tool. So we are certainly seeing many clients going back and revisiting and reviewing their security situation. And if they don't have security for their loans, asking the questions about how they get that security.
Absolutely, and that's a very wise thing to do for a bunch of reasons. The first one is, as I said, using a receivership is a way to restructure, but it only really is effective if you're the secured creditor or plus secured creditor. And if you have money in a company and you have security, your primary lender is going to want you to subordinate to them. But at the same time, you've probably got a guarantee to that primary lender. So they're getting paid out, full, and that's fine. But for the most part, in my experience, that first secured lender is getting paid out full. And there's a little bit more money trickling down to everybody else. If you're just a shareholder, you're getting none of it. If you're an unsecured creditor of the company, you're getting a little bit of it, but you're sharing with everybody else. And frankly, why should you? If you're operating the company, you have the ability to make sure that your advances are secured. And then that next flow of money is coming to you.
And it provides a very useful level of control. I think, Wojtek, you mentioned earlier the ability of a secured creditor to not just demand payment, but to appoint a receiver, and that receiver to run a receivership process that allows the business to be restructured. And that is a very effective tool that can be used in tough times so that you lose your entire investment.
Yep.
But I think based on what I'm seeing here, it looks like it may be time for us to move to our last presentation of the day. Wojtek, thank you very much. For anyone that has any questions, whether it's about restructuring, whether it's about having clients or customers or suppliers that apparently are going through restructuring, please feel free to reach out to Wojtek directly. I'd be glad to help you out. And now I can introduce Sean Singh, a member of our commercial litigation group, who's going to talk to us a little bit about some of the impacts of COVID-19 in the commercial litigation sphere. So Sean, please take it away.
Thanks, Ian. So just as Ian mentioned, I am a lawyer in our commercial litigation group. And so we've seen kind of an uptick of coming and saying, well, this pandemic is obviously something that is unprecedented. Does my contract allow me for some type of relief? And when we're talking about the contracts, we're looking at things, really, it could be any types of contracts. So we're talking about commercial leasing agreements, as Jennifer mentioned. We're talking about supplier agreements, third-party agreements, and things and so forth. So I'm going to just kind of get it started and talking about, what is a force majeure clause, its applicability, how the courts have kind of determined it, as well as the doctrine of frustration and whether or not that may be applicable to your situation. So force majeure, you'll see kind of a lengthy definition here that the courts have used, being a provision in contract that temporarily relieves the parties of performing their obligations when it just doesn't make sense because of the situation that we're now surrounded by. The key word there is temporarily. When you're looking at the difference, or the main difference, between a force majeure clause and the doctrine of frustration, we're talking about the timing. So the force majeure clause is going to be something that allows a party to be relieved of certain contractual provisions for a period of time. So from the time that, for example, this pandemic has started until we start to get back to some semblance of, quote unquote, normal, that will be the period in which one of the parties that is seeking to rely on the clause will be relieved from their obligations. When we look at a force majeure event, that's something that's outside of the control of the parties. It's something that they really couldn't either have predicted or are forced now to adapt their entire business model or business strategy according to what's happening in the outside space. You'll see here, the clause is not necessarily going to be called force majeure. And the actual language of the heading itself doesn't matter. What really matters is the substance. What do the clauses in your contract say? And you may say, okay, well, I went through my table of contents, I don't see force majeure, or I do, and how does it apply? But you might see it in the general conditions, miscellaneous conditions. Realistically, we're looking at the substance in accordance with how does this type of situation affect me, and could I be relieved of obligations? And just as a kind of point of order or note, it's generally used as a defense. You typically don't see a force majeure used as your cause of action or to commence an action against the contractual party. But that's not to say that it can't be. You'll generally see it as saying, okay, well, I can't perform these, so if the other party starts an action or an application, I'll be in a position where I'm going to be relying on the force majeure clause as my defense to why those things happened and why I was unable to perform said obligations. So the ability to claim relief for force majeure really depends on the particular language of the contract. Now, I'm not necessarily referring to the heading, but the substance of that clause is paramount. And the courts have said that although force majeure clauses do vary widely, they'll look at a careful reading of the provision itself to understand whether your performance can be excused or not for that particular circumstance. And you'll see here, I've listed types of force majeure provisions being broad, specific, and general. And realistically, they could be a hybrid of either one or two or one or three or a combination of all of them. When we look at a broad force majeure provision, we're talking about something that broadly states that the parties will not be liable for failure to perform their contractual obligations, maybe due to a force majeure event, full stop. They may not provide specific details as to what a force majeure event is. They may not provide details as to which obligations are relieved, and it may just be kind of a blanket statement. When we talk about the specificity of the provision, so the specific performances, we're talking about the specific circumstances beyond the control of the parties that fall within the scope of that provision. So, for example, things like war, strikes, civil disorder, or adverse weather conditions are things you do typically see in some of the specific provisions. And then you've got some general provisions that have kind of catch-all language that extend the application of the force majeure provision to other intervening events. And so it really does depend on what your particular contract says, because you may have, I'll take an example where you may have the same supplier as one of your other colleagues in business, but just because that's the case, it doesn't mean that your ability to rely on the force majeure clause will be the same as them. In fact, it's probably very different. So in order to rely on this provision, there's a couple of things that the courts do look at to say, okay, well, does this constitute a valid defense, and is the force majeure event applicable to the situation at hand? The two being that the event was the cause of their inability to perform was their delayed performance, and it was beyond their control, as well as there being no reasonable steps that they could have taken to avoid the situation or mitigate their damages or the consequences of the event itself. And so those are very kind of important considerations, because while it may be that the event is something that is correlated to why you can't perform your contract, the courts will do an in-depth assessment to say, is there something else that could have been done? Is this really the cause of your failure to perform in contract, or was it something else? Can we tie the event? So let's say COVID-19, can we specifically tie the circumstances surrounding COVID-19 to your failure to perform under that contract? Now, the other note that I've got here is that the party that is looking to rely on the provision needs to ensure that it complies with all the procedural requirements under the contract. So the force majeure provision, as I've said, is a provision in contract. You'll have things like notice requirements that you will still need to provide the other contractual party, and there may be timeframes that you need to comply with. So it may say that in the event of default of contract, you need to provide notification within 14 days or 10 days or within a month. So those are other provisions that you do need to carefully look at to ensure that when you are relying on this provision, you do satisfy the other requirements that you've entered into your agreement with. There may be a requirement, for example, to provide updates on performance delays. So for example, if I've got a supplier that cannot provide me with the 1,000 widgets that I require every week, well, maybe they're able to provide me with 300 this week, and as their capacity increases, they have an obligation, or they may have an obligation, to provide me with constant updates as to either what they're doing to ensure that the delay is not going to affect them any further, or the change in their circumstance. So maybe they can produce more, maybe they're forced to a situation where they produce less, but making sure that the other contractual party is updated as to the situation. And just as a practical consideration, when you think about this being a situation where litigation may or may not be involved, you do want to ensure that you are providing enough information so that immediately the other contractual party is not going to say, listen, I haven't heard from them, so we've got to start an action. And I have heard that from several of my clients, and that's the situation. And as I've said, there is an obligation to mitigate damages. So while the COVID-19 situation may have prevented you from being able to perform your obligations, are there other things that you could do within reason to be able to mitigate some of the effects of COVID-19? So that's one of those things that will be very specific as to the contract itself. And a quick example may be in the franchise context. Let's say you've got an exclusive supplier, and that exclusive supplier is not able to provide you with the amount of product that you need for your business and for your franchisees. It may mean that you have to speak to them about waiving exclusivity so that you can obtain various suppliers for the same product for a temporary period of time to ensure that customers and franchisees are impacted to the least extent as possible. And again, as a practical consideration, even if there's no notice requirements, it's advisable that you communicate both with the other contractual party, your customers, your suppliers, to let them know if you're not able to perform your obligations. Now, you do want to be careful in terms of how you're wording things, and you do want to be honest with them, but at the same time, you want to ensure that you're giving enough information that they need to be satisfied, but you don't need to give away everything. So the precise language of the clause is going to be essential. You'll see in various provisions, we'll have an act of God or something beyond the party's control. It's arguable, and there's really no case law that I've come across that speaks specifically about how the pandemic has affected parties and if they could rely on this provision using act of God or beyond the party's control. And realistically, in my opinion, I don't think that that's sufficient. I don't think it's specific enough that you will be allowed to just rely on an act of God or something beyond the party's control. If the language does include things like pandemic, epidemic, quarantine, public health emergency, outbreak, or disease, you're more likely to say, okay, I can rely on that clause. Now, you may say, Sean, that's probably highly unlikely. It's never going to happen. This is an unprecedented situation. So how would this language be in my contract? And I have seen, it is few and far between, but I have seen at least one contract with one of our clients who was around and operates in the States during SARS, and they do have this language in their contracts. And so it's good to always take a review, say, just in case, let me take a look and see if this may be applicable. Now, if there's no force majeure provision, it's likely that your only option is to rely then on the doctrine of frustration. Frustration occurs where there's a supervening event that effectively changes the nature of the rights and obligations, that it'd be impossible to hold the parties to that contract. The situation is completely different, effectively. The difference, again, as I've mentioned, is force majeure talks about temporary, and a frustration is the parties are permanently discharged from further obligations. So it effectively puts the contract at an end. The event needs to go to the core purpose of the contract. So where there's things like ancillary clauses that may be breached as a result of a pandemic or an epidemic or the COVID-19 situation, unless it goes to the heart of the contract, we're in a situation where it may not fall within the doctrine of frustration. And that leads to the last point there. The standard that the courts hold parties to with respect to finding that frustration is applicable is much higher than that of a force majeure provision. And they do a very thorough assessment to ensure whether or not it could be triggered and relied upon by the breaching party. In order to rely on the doctrine of frustration, the parties need to consider the existence of a force majeure clause, the frustrating event, and the performance of the contract. And I'll go into those in a little bit more detail. So in the event that there is a force majeure clause or none, that's an indication that generally the parties have turned their mind to what will happen in the event that there is a force majeure clause, that what will happen in circumstances of uncertainty. If there's no force majeure clause, it's more likely that the court will say, you know what, the parties may not have turned their mind to this, and we should intervene. We look at the frustrating event itself, and that occurs again where there's no fault of either party. that could have been reasonably contemplated and foreseeable at the time of the contract. It needs to be directly linked to the frustration or the the purpose of the contract in order for it to qualify. And again, with performance, it needs to render the performance of that event, of the contractual obligations, effectively impossible or radically different from what the parties had originally agreed to. When you look at the two together, and I've mentioned it a couple of times, but the big difference between the two remedies is timing. Force majeure is temporary and will start typically around the time that the event takes place until the economy changes or the event subsides. Frustration, if you're relying on that doctrine, you're no longer bound by any future obligations. So when the event is handled and there is that return to normal, you no longer have a contract either with your suppliers, third parties, customers, etc. And finally, just to say, when you're assessing your contracts in this COVID-19 world, what should you be looking at? And again, it's important to carefully review all of the provision in its entirety. Review the definition to determine if there's an express event that would capture COVID-19 or if the general language may be sufficient. Ensure that your inability to perform under that contract is related to COVID-19 and is not just ancillary to. If you're in a business that you're struggling well before COVID-19 and are trying to rely on this provision now to excuse you from some of your contracts, it's likely going to fail and the courts will see through it. Consider the steps that you need to take to mitigate the possible effects. So maybe finding other suppliers, maybe entering into some other related type of businesses, whether it's products that you're going to be carrying and changing your business to minimize the damage that could be suffered. And then also make sure that you comply with the procedural obligations that are related to your contract. So welcome any questions that may come up.
I just had one question for you, Sean. If you could if you know this, and it's not related, but I thought you might know, and that is the situation with the courts. They're closed. I'm glad to see you. I thought all you litigators were away on vacation, but here you are. Has there been any update on when the courts will be more open than they currently are for just emergencies, or have you heard anything about that?
Yeah, so as you've touched on, the courts right now are really open for urgent matters and then consent motions in writing on the civil side. And in family and criminal, it is a little bit different. But for the commercial and civil side, realistically, if you'd like to get some kind of action done, it's either going to be because your matter is urgent, which is defined by the ministry. And so while it may be urgent to you and I, it is not necessarily urgent to the courts. Or whether it's something that both parties are consenting to, you can submit it electronically in writing, and a judge will review and give you a determination on it. With respect to the opening of the courts themselves to be at a more full capacity to start hearing motions, whatever that may look like, or trials and things of that nature, we're looking around July 6th. The most recent update that we got was no earlier than July 6th. And I think that the ministry is also working kind of with the information they have at hand. So it's possible that that changes earlier. I don't know whether it's likely, but they did announce, I think it was 2 days ago, that we're looking around July 6th to be an opening date.
Okay. Well, thank you very much. And thank you as well for the presentation. For all of our attendees, just wanted to let you know that we will be following up with an email with the contact information for all the panelists, as well as their individual presentations in a link, so that you can either look at it, look at the ones you wish to review again if there's anything you missed, or send on and share to others. And again, we thank you very much for joining us, and we hope it was useful. Thanks again, everybody. Stay safe, and we will see you all hopefully in slightly better times. Thank you.